Where the accused order has been passed on Friday. Now, it pertains to a tea garden where on 18 January it appeared that without any authority of law, the state government is patronizing a third party to enter into the garden and pay the wages. We have a subsisting lease till 2035.
So you pay the wages?
I'm ready to pay the wages. Now,
First you pay the wages and come.
The honorable single judge.
First you pay the wages and come.
We are ready to pay the
Assumption will be stopped. Everything will be stopped.
Right.
Come with clean hands.
My only respectful submission. Kindly allow me to file this without the certified copy.
You've got the server copy.
Server copy is there.
My
second prayer, I have led my Mr. Somendranath Mukherjee and senior counsel. He has kindly requested. So Lordship takes it up at 2 p.m. today. By that time, I will... Tomorrow,
Tell
Mr.
Somendranath Mukherjee, the judges have said, pay the wages and come.
No doubt about it.
So tomorrow,
and come back
tomorrow, by that time, make arrangements for payment of wages and it will be at the top of the list. Give notice to the additional advocate.
Absolutely.
Right.
Lordship, may I be permitted to mention a matter? This is for correction, Lordship. I'm grateful.
My lord, I am praying for mention, my lord.
Yes.
My lord, I am praying for mention for inclusion in the list, daily list, my lord. Bail in connection with appeal, my lord.
All right, give the slip. Call the
My
list. Yes. 3 and 4.
3 and 4.
Yes. Who is for appellant?
Lordship, I am for.
You have been appointed. All right. Take necessary steps. Mr. Saurabh Ganguly appears for the appellant. You have filed appeal?
Lordship, yes, Lordship. We have this is paper book also.
Paper book. So, next circuit or
Whatever, Lordship.
no, whatever means you're ready to argue.
Lordship,
You're ready to argue. Who is for state?
Mr. Aditi Shankar Chakraborty is there. Along with Arjun.
Then
this was appointed by the DLSL.
right. So when should we keep it? It's a conviction under
302, Lordship.
302. How many people were murdered?
Lordship,
How many people murdered?
one only, Lordship.
Then why death sentence?
Lordship, there are ambiguities because the court was brought as 3 eyewitnesses are there, so-called eyewitnesses. But after scanning the evidence, Lordship, the presence of the accused in the place of occurrence is very much doubtful, Lordship.
Where is Aditi Shankar or Arjun Chaudhary?
There are serious contradictions, Lordship.
Correct. Then we will keep this matter on if you want to argue it, we keep it on a particular day, maybe day after tomorrow, 2 p.m.
PW1 is the eyewitness, no?
PW1 is the eyewitness, but other witnesses says she came afterwards.
Let us see. But this is the Arjun is coming. Where is Arjun? Where is Arjun Chaudhary?
কবে করবি?
Aditi Shankar.
Pilot যখন বলবে আমি-
Yes, Mr. Aditi Shankar.
ডেথ রেফারেন্স আছে, এটা কবে করতে পারবে? এটা হচ্ছে ওই মার্ডার কেস, রামদাদি মেরেছিল ভক্তিনগর থানার, আই উইটনেস আছে, কি দেখেছেন? PW1
Three eyewitnesses.
Tomorrow.
বুধবার।
We'll keep it on day after tomorrow, 2 p.m.
Grateful, Lordship.
Mr. Saurabh Ganguly, heard Mr. Saurabh Ganguly and the public prosecutor, and heard Mr. Saurabh Ganguly for the appellant and the public prosecutor. Fix the matter for hearing on Wednesday. 2 p.m. 2 p.m. Yes. Next matter,
Lord, in 5 and 6, I appear for the appellant, my Lord.
you are for appellant.
Yes, my Lord. Lord, honestly, I have not been able to ready myself with the bill.
No difficulty. Mr.
Lordship, state.
You are for state. So next circuit,
Next
on the
slide.
prayer of the appellate, next available circuit.
Grateful, Lordship.
Yes, 7. 7,
Lordship, I have been appointed from the High Court legal.
so you file the appeal,
Lordship, we have to file the appeal.
right? Mr. Saurabh Ganguly has been appointed on behalf of the convict. He seeks time to prefer appeal against the judgment or an order of conviction and sentence. Let the matter appear in the next available circuit.
Grateful, Lordship.
Steps be taken in the
Lordship,
name.
Lordship.
Yes, next matter.
Lord, in 8, I appear for the petition. Lord, Mr. Chaudhary, Arjun Chaudhary was for the state.
Yes. This is what?
My Lord, application for bail, my Lord.
How long you are in custody?
My Lord, 35 days now. Lord, my
So-
implication arises from a confessional statement of the principal accused,
Where
which
is
has not led to any recovery.
investigating officer, Mr. Aditi Shankar, investigating officer was directed to be present?
Present হবে।
Case diary is there?
Yes, ma'am. Present.
What is against this person? Any recovery?
My lord,
Statement assessor.
Passed over, you go through the case diary and submit. Next,
The paragraph number 9, take to appear on behalf of the petitioner. Lordship, NCB personnel has conducted this,
give notice to Deputy Solicitor General.
already given, my lord.
So where is, who is appearing? Do you know?
This is the first time, my lord.
Correct. Who is appearing?
Ajoyda and Sanjay,
To inform them, we are keeping it tomorrow,
my lord.
not today.
Great.
Next,
Item number 10 and first,
wait,
not
your
the
lordship.
short password, it is CY matter. learned
passed
DCL.
over, Mr. Mitra. Next,
For the petitioner. My lord, I am for the petitioner. Actually, this, after rejection of the anticipatory bail, I was surrendered before the court of London, CGM Jalpaiguri, and since then, I am in custody, my lord. Lord, kindly see the contents of the FIR, my lord. That is page number, my lord, 9. At the first instance, my lord, my name transferred as the FIR, but in the third paragraph, it has been awarded in separate manner, my lord.
we have directed some clarifications from the
Yes,
investigator.
clarification regarding lordship statement of Momita and Goglu. Goglu is only 2 years old. Lordship have record the statement of Momita.
Momita is,
6 years old.
did they suffer injuries?
Momita,
Did they suffer injuries?
no lordship, only Goglu.
My lord, my lord, one indulgence, may I seek, my lord?
Who died?
The PA is the child of.
Who is the child? Name of the child? Deep. Deep is the name of the child. You are not prepared, Mr. Luksum.
3 children were there.
Where is Arjun Chaudhary? He was assisting this court. Huh?
Who died? Lordship, Deep Mondal.
We know.
Deep Mondal is the
It's a wonderful discovery for you, not for us.
4 years old.
Our queries are there. Have you seen our earlier order?
Yes, lordship, Momita and Goglu were present. They were traveling, lordship. That is the statement of Momita, lordship.
Not today. Please don't embarrass yourself and force us to be harsh with you. Yes, next matter.
I appear for the
And why
petitioner.
public prosecutor? Some lawyer appears on one day, another lawyer appears on the other day. Yes, next matter.
My lord, I am for the petitioner.
I'm for the state, your lordships.
My lord, charges are under section 498 and 304B of the Indian Penal Code.
Hmm.
I am the husband, my lord.
Hmm.
I was arrested on 25th of June 2024. Charge sheet has been filed on 1st of October 2024.
Hmm.
Two other, my lord, FIR named accused, my mother and my unmarried sister,
Hmm.
they absconding. And in the charge sheet, my lord, another sister, married sister was implicated. She was granted bail by the learned Sessions Judge Jalpaiguri, my lord. I am in custody for 216 days, my lord.
Lordships. Lordships, from the postmortem report, your lordship will be found that the others injuries also reached injury marks is there, the husband. And moreover, your lordships, the victim was pregnant 8 months. And all the allegations and lordships charge already framed and schedule has been fixed. And next date has been fixed on 5th February 25 for CS1, 6 February 25, 2 and 3, 7 February for 4 and 5. Schedule framed, your lordship, principal accused, and the allegations serious, your lordships.
Where is,
Lordship reached and others,
where?
lordship, upper portion of the. Top of the lordships is.
Huh?
May I, lordships? Reached,
Ah. Hold on.
the husband, your lordships.
First cut a vein and then one measuring the back of the head. That is something.
And page 9, 10, 11 all are against the.
Petitioner is the husband. He contends he is in custody for 260 days.
216.
216 days, investigation is complete. Co-accused, that co-accused sister-in-law has been granted bail.
And 2 are absconding.
There is no possibility of trial commencing in near future. He prays for bail. And a lawyer for the state submit. Victim lady suffered injuries on her wrist and head. Victim lady was tortured by the petitioner husband over demands of dowry. She was physically assaulted. Apart from ligature mark, other injuries are also noted. Date has been fixed for consideration of charge.
Charge has been framed, my lord.
Framed. Charge framed, schedule also framed.
Date has been fixed for examination of witnesses. We have considered the materials on record. Petitioner is the husband. Victim is his wife. It is statements of witnesses disclosed. Petitioner and in-laws subjected the victim to torture over demands of dowry. Petitioner was present at the place of occurrence. A PM report shows a victim suffered injuries in the wrist and occipital region of the head. Apart from the ligature mark, victim suffered. This gives an impression of physical assault prior to the incident, prior to the suicide. Date has been fixed for recording evidence. Under such circumstances, we are not inclined to grant bail at this stage.
Obliged to your lordship.
Co-accused sister-in-law does not stand on the same footing with it. Next.
Lordship, I am for the.
Yes,
Lordship, I pray for an adjournment, Lordship, as because I have instruction to appoint a senior in this case, because the victim girl not been served even. The victim girl, this is the 5th case filed by the victim girl under section 376. 4 cases against other persons.
where is that?
Lordship, we have filed all the order sheets and annexures of those documents, Lordship. And cases are pending against the victim also regarding laundering of money and other.
Which paragraph you say?
Lordship, Lordship, can you see paragraph number 9?
9. Or let give notice to the victim.
Lordship, can it be fixed on 30th?
Officer in charge so and so shall give notice to the victim with regard to pendency of the proceeding and her right to legal representation through High Court Legal Services Committee, Thursday.
Grateful, Lordship.
For the petitioner, my lord, I have served the my lord victim dating. Copy has been served on victim dating. The petitioner before your lordship is the father-in-law, my lord. The petitioner is in custody under custody is the
164 of
petitioner in custody is 60 days, my lord. Charge sheet file, my lord. Defector complainant late term matrimonial home, my lord. The husband of the defector complainant file, my lord, restitution of conjugal right. No notice has been served. And next day the FIR has been lodged.
Give notice to the victim.
Or I have served, my lord.
Officer in charge shall notify the victim. Next date of hearing and a right to legal representation, Thursday.
Grateful.
Lord, in 15, I appear for the petition.
Yes.
Lord, on the last occasion, the state was directed to notify the
Right.
victim. My lord.
Hmm.
Victim as well.
Have you given notice to victim?
Notice not served, your lordship.
Why? Wednesday.
Wednesday.
State seeks time to serve notice on victim, Wednesday.
Obliged.
Next,
Lord, I am for the petition. Lord, in this matter, there is a 21st of January, there is a direction upon the state to serve the victim girl, my lord.
We have intimated.
let
Lord,
us
this is
see
the case
what-
under section 137 to 143.
The
And
father of the victim has been intimated.
How anticipatory bail in 2017 case?
Lordship, he was declared a proclaimed offender,
Then-
that thereafter the order of proclamation has been set aside. And
So-
in that order, liberty was given to the petitioner to seek to avail remedy, Lordship. That way, immediately after the setting aside of the order of proclamation, we have filed an application for anticipatory bail.
My lord, on last occasion, my lord, let's call for a report for the already pending cases, withdrawal or not, my lord. That report already come, my lord. My lord, 15 cases has been withdrawn, my lord.
Acha. 15 cases withdrawn. How
Yes.
many cases were registered against you?
My lord, total case, my lord. 100 something, my lord.
In how many cases is he on bail?
No. Particularly in this case, my lord, 80 witnesses is there, my lord. Total accused is, my lord, charge sheet accused is 27. Bimal Gurung is, my lord, FIR named. 9 FIR named accused in the particular in this case, my lord. Total absconded accused person, my lord, 18% in this case. And
How many people are in anticipatory bail or bail in this?
9%, my lord, 9%.
80% are charge sheeted.
80 is the witnesses, my lord.
How many persons charge sheeted?
Charge sheeted, my lord, 27.
27
this
charge
case,
sheeted,
yes.
of which how many people are on bail?
9.
9 are on bail.
Yes, my lord.
Out of 27, 9 are on bail, right?
Yes, my lord.
18
18 are absconded, my lord.
18 are absconding. And what is against them?
My lord, 161 statement of the police witness, my lord, it's come, the present petitioner is present and the recovery has been done the place of the present petitioner.
What
The firearms, my lord, and page 99, to my lord. 161 of the one of the eyewitnesses, my lord.
Mr. Public Prosecutor, what you do is you give a short note
my lord,
What is the criminal antecedent?
my lord.
What are the cases against him? Whether he is on bail or not on bail in other cases?
My lord.
Which cases have been withdrawn? And the memo of the evidence which has been collected against him. The thing is that police raided a camp
Yes,
and these persons were there in the camp and they were seen running away or
running away from the. And from this camp, the firearms has been seized
correct.
along with the other materials, my lord.
Anyone died?
Yes, 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 one police personnel.
Who lodged the FIR?
My lord, FIR lodged by the DSP Darjeeling, my lord.
Inspector Shomojit Rai, he is the complainant.
My lord, my lord.
Huh?
Somojit Roy, IC Sadar PS Darjeeling.
Bhai, he is the complainant.
Yes, my lord. He is the complaint.
In the further statement, he specifically says Bimal Gurung fired.
My lord.
Why in the FIR this was not there?
Lord, actually, my lord, if apart from the FIR, my lord, on the charge sheet, my lord, first charge sheet has been submitted on 25th January.
Mr.
20
Aditi Shankar, see the further statement. Ran away, he was away. They declared him proclaimed offender. He went to Supreme Court. Supreme Court, I think, said that he take appropriate relief in accordance with law, and now this file and so it will be application. 2024. You have seen
Yes,
that
my-
line.
Yes, 160 he has come.
What we are saying is, what is his role? His role is in murdering or sharing common intention of murder. Is he the murderer, or is he sharing common intention, or he is a conspirator to commit murder? What is your case? Because this appears to be an embellishment. A complainant in FIR does not say the petitioner fired to kill one of the police officers. However, in the further statement implicates the petitioner that he fired. And the entire thing is, there is a political agitation. In the course of political agitation, an indefinite band is called by a political outfit.
Party.
The political outfit has not been declared an unlawful association or a banned outfit. Series of cases have been registered against him. We want to know what is the series of cases registered in 2017. How many of these cases now you have withdrawn? See the paradox of your stance. The starting point is violent agitation. Number of cases. These people, part of the violent agitationists, have taken refuge in camps around Rangit River. A police action against them. They are running helter-skelter, firing at police indiscriminately. As per FIR, Gurung and others are also seen running away with a. However, no allegation that they were firing. In the course of this skirmish, one police officer is injured, dies. FIR is registered. He says that there was an a warrant issued proclamation. They went to Supreme Court. This court set aside. When was it set aside?
First charge sheet, my lord, there is no name of the present petitioner, my lord. Thereafter, the supplementary charge sheet, the present petitioner name has been transferred, my lord.
Mr. Aditi Shankar, you understand the quality of evidence that is being laid against him? In the first charge sheet, he is not named. And then the second charge sheet relies on a further statement of the complainant himself. If the complainant saw Gurung fire, how will he miss that in the FIR? We keep it tomorrow, Mr. Aditi Shankar.
One.
You just indicate to us if it is there in the FIR. If it is there in the FIR, why in the first charge sheet he was not shown as an accused? It is there. And then the first charge sheet, when the first charge sheet was,
My lord, 25th January 2018.
and in that,
Present prisoner are not there. And thereafter, my lord,
Why?
after 2 days, my lord, the supplementary charge sheet has been.
why present petitioner was not there? Because in that charge sheet also, at page 85 of the petition, the statement is recorded that he had fired. This page 105, Bimal Kurung is named amongst the 27 charge sheeted.
Yes, my lord.
Then please give us a clear picture when he was charge sheeted, because accused number 20.
My lord, first charge sheet has been submitted on 25th January 2018, my lord. On that charge sheet, my lord, the present petitioner name has not transferred, my lord. On the second supplementary charge sheet, my lord, on 27th.
Where is the first charge sheet?
First charge sheet, my lord. Running page, my lord, on the main petition, my lord. 38, my lord, name can be ascertained 38 and 39, my lord.
Hmm.
38 and 39. 4 person is there.
Hmm.
Suraj Pradhan,
Hmm.
Sham Kami, Mahendra.
What is the reason why he is not charge sheeted in
There
the
were
first
exceptions.
charge sheet? Why is he not charge sheeted in the first charge sheet? Then does it mean that you don't believe the complainant? Why, when they complain, the person is said to be the principal offender who fires at the deceased, SI Amitabh Mollik, and Amitabh died.
Amitabh died.
So Amitabh Mollik is fired by Bimal Guru. This
As per
statement is coming from the complainant in the FIR. But in the charge sheet, first charge sheet, he is not named as an accused. And even in the second charge sheet, there is no specific charge of murder against him. He is charged only with conspiracy to commit murder. It seems that your police themselves don't believe the complainant. We want this explanation. How is it the FIR saying Bimal Gurung fired? In the first charge sheet, Bimal Gurung is not made an accused.
kindly fix your my lord, day after tomorrow. I have already.
And you also place on record all the cases which were registered against Bimal Gurung and his party in 2017, and what are the fate of these cases? 15 you have withdrawn. What about the others? What happened to all these cases? Very good. So I want that chart. Have you a chart of these?
I had a copy.
These what you are giving is a sheaf of papers. We want a chart. 19 cases. Form a chart of case numbers, status,
My lord, that report already, my lord, submitted, my lord, today. 15 case, my lord.
this is a chart of 6 cases. Then Yes, hand it over. We've seen it's a case, list of 6 cases. Make a comprehensive chart. Cases which are pending, whether you are on bail, you are not on bail, cases which were pending and have been discharged. This is the 2 categories. Some cases where you have been cases withdrawn against you. Some cases where you are on bail. Some cases, if any, where pending, you are not on bail, including this one. Please share it amongst both of you. And we keep this matter on Thursday. All right? And one explanation, Mr. Public Prosecutor. FIR named accused,
Why not?
the principal accused who is shooting as per the complainant is not made a accused in the initial charge sheet. And in the subsequent charge sheet also, the charge sheet is been filed against him under 120B 302 and not 302 simpliciter. For him, the charge should be 302 simpliciter. If he is firing and others aiding and assisting will be 120. We understand if the charge is not a final one, but the charge gives an indication of how the investigating agency is perceiving the evidence collected by it. Is the investigating agency in omitting the petitioner as an accused in the initial charge sheet and in the subsequent charge sheet charging him for as a conspirator, not believing the statement of the complainant that it was he who had fired? This is definitely a thing which is of relevant, because for us, if there is a clear unequivocal evidence that this man had fired resulting in death of police officer, we are the last person to give him a dispute. However, if the charge against him is one of constructive liability in the form of sharing common intention or being a member of an unlawful assembly or conspiracy, we have to see it in the wider canvas of political strife, the extent of his role, and the possibility of roping in. We find that a very incongruous stance, and added to it the stance of the state in withdrawing cases against him. Why the state withdrew the cases, which appears to be one of the triggers for the police action where the police officer died. There were series of cases. Why you have withdrawn the other cases? Heard learned counsel for the parties. The state shall clarify the following points. 1. In the FIR, it is alleged the petitioner had fired at one SI Amitabh Mondal Mollik who succumbed to his injuries. Strangely enough, notwithstanding such unequivocal accusation, strangely enough, petitioner was not cited as an accused in the first charge sheet. Even in the subsequent charge sheet, he was charged as a conspirator and not a principal offender. Full stop. This state shall explain on the following points. Full stop. This dichotomy requires to be this dichotomy in the accusation, in the manner of accusation, this issue, full stop. Number 2, state admits it has withdrawn 15 criminal cases against the petitioner under section 321 CRPC. The rationale on which the cases were withdrawn vis-a-vis other cases which are pending against him needs to be clarified. 3, it is contended on behalf of the petitioner that he has been granted pre-arrest bail. His proclamation, order of proclamation / attachment was set aside. However, the warrant of arrest is still pending. It is contended petitioner was available to the investigating, it is contended in the interregnum, petitioner was granted pre-arrest bail in some cases and had appeared before the jurisdictional magistrate and was released on bail. If that is, this is not disputed on behalf of the state. Given this situation, the state requires to explain why, in spite of the petitioner being available on surrender in those cases, why the warrant of arrest was not executed against him. Full stop. The report who is heading this investigation?
My lord, CID.
SPCID shall submit
Not SSCID.
SSCID shall submit report on the adjourned date. Matter will appear on Thursday. You understand, Mr. Aditi Shankar? Three things are really not matching up. One is FIR principal accused. How is he not named in the charge sheet? And even if in the supplementary charge sheet, the charge is not against him 302 simpliciter, but of a conspirator. Second is the rationale on which the state has operated. Why certain cases were withdrawn while others were not withdrawn. 3, you claim that he is a proclaimed offender, all right. Proclamation for technical reasons was set aside, warrant is pending. During this time, it is their case, they have got anticipatory bail and appeared before the jurisdictional court and have been released on regular bail. So they were available to the state police machinery on their appearance. How is it that the warrants were not executed? And why the warrant was not executed? Please give this explanation and then we will consider. So if that is so, why? My thing is that politically, whatever be the reason, if there is clear evidence that he had shot the police officer, we are not going to. Because whoever you may be. I don't know.
Kindly there be an interim protection till Thursday.
What interim protection? Do you seriously apprehend arrest? We are not puppets in a political drama, sir. We are forensic entities examining your culpability. You may be politically aligned with the political executive in the state. You may be politically antagonistic with the political executive of the state. Not our concern. If your client had fired a police officer who died, you have to suffer consequences. And for us, it is a matter of wonderment that a complainant police officer specifically blames you as the person who fired, but the investigating agency does not file a charge sheet, the initial charge sheet implicates you. Even the second charge sheet does not implicate you as the principal offender. From 2021, you have demonstrated to us you're available to the police administration. They have not arrested you. What protection are you asking, sir? The state appears to be protecting you. If you wish to pursue the application, pursue the application. But if you pursue the application, we see it from a very forensic point of view. Next.
Unmute. Lord, in this matter, I am appearing for the petitioner.
Yes.
On last occasion, my lord,
Yes.
have been pleased to direct the
Lordship, IO has appeared personally with a report. Actually, in the report, it has been clearly stated that from 3rd January 2019 to 8th August 2019, 110 Kishan credit loans were sanctioned from a Jalpaiguri branch of Uttar Bengal.
Our query is, was the petitioner otherwise entitled to the Kishan credit loan which had been sanctioned in his name?
Actually, so far I have asked the IO, he stated me that the petitioner is also a farmer. But Lordship, the petitioner actually took the loan by submitting forged documents, even
Correct.
changing his father's name.
Father's name has any relevance to the identity of the petitioner as a farmer?
Lordship, actually, name of the father, address of the petitioner who got the loan, all has been forged. And actually 110 Kishan credit loans which were sanctioned, after the inquiry, it has been found that all these actually forged the KYC.
What about the principal offender who had?
He is in jail custody. Pintu Bhadra, he is the manager who engineered the entire racket.
Right. And Pintu got how much money from this petitioner?
1,90,000 was sanctioned in favor of the petitioner. So far the petitioner returned 1 lakh rupees, and regarding 90,000 the petitioner has consumed.
Petitioner has not returned.
Not returned.
You return 90,000, we'll consider.
But I am not getting 1,90,000. I am only
That
getting
is your
only
headache, sir.
1 lakh.
Your headache, the
My lord.
cooperative society has lost 1,90,000 through you. If you are willing to deposit that amount, it is an impact on the gravity of the
My
offense.
lord. My lord.
Otherwise, in this sort of an organized crime activity, we are not going to give you answer.
My lord. Blood shall deposit.
Huh?
Yes, blood, I shall deposit.
When?
Balance 90,000.
Friday we are giving it. Petitioner,
My lord.
he was entitled to Kishan Bikash, Kishan credit, Kishan loan under
KCC loan.
under Kishan credit card scheme. He had been sanctioned a loan of rupees 1,90,000. He has returned rupees 1 lakh and undertakes without prejudice to his rights and contentions to deposit the remainder 90,000 before the jurisdictional court, subject to the result of the litigation. In light of the aforesaid submission, petitioner is given liberty to deposit a sum of rupees 90,000 before the jurisdictional court. And in the event the deposit is made, the said court shall keep the amount in an interest-bearing, auto-renewing, recurring fixed deposit account maintained in a nationalized bank, nationalized bank in the name of the company, a nationalized bank subject to the result of the litigation. Matter will appear on Friday.
My lord, I am protecting
You
protection
will not-
up to my lord Friday, my lord.
no question of you're being arrested in the meantime. Don't worry.
My lord, grateful.
Lordship, the personal appearance of the IO may kindly be dispensed of.
No, IO will come and say whether the deposit has been
Oh.
made. IO shall submit report on the adjourned date.
Much obliged.
All right. If he gives 90,000, then all right, custodial interrogation
Not-
not necessary for recovery of stolen property. We will get answer.
Much obliged.
I'm grateful.
Yes, next matter.
Lord,
I'm for the petition.
20, my lord, the co-accused person's application is item number 11. And Lord, in that matter, your lordship has called for a report. Further medical opinion.
Oh, that one.
That one.
That
my lord.
All right, along with 11.
Yes.
Along with 11. But he was not there in the car.
This petitioner was not there.
He will, all right, we'll consider along with 11. Please clarify that. That's why we have, because Mr. Laksam was completely he was unaware of the event. Whether Guglu and Mampi suffered injuries or not.
My lord, medical opinion has not yet come because my officer has approached the doctor. Doctor has taken time till 1st of February. That is what, my lord, the report.
Time till 1st of February.
For giving opinion, my lord. That is the report says.
We want the opinion by next day.
My lord.
Fix
My lord.
it tomorrow, my lord.
Yes. Tell the doctor we want the opinion today.
Lordship.
All right.
I'll pursue the matter. Yes.
First opinion with regard to cause of death.
My
The second question is, Mr. Bhomik says that the car turned turtle.
My lord.
What about the other occupants in the car? Did they suffer injury?
No.
They did not suffer.
So that rules out the possibility of an accident.
Yes. My
So this is the prosecutor's responsibility.
My lord.
Show the circumstances which improbabilizes the defense. He's taking a defense. At least he is not disputing his presence. Says, I didn't kill him. It was a case of
Accident.
road
traffic accident.
accident. If there's a road accident, did the other children suffer injury? That is one of the relevant factors to be considered. So it's no. Now get an opinion in the course of the day from the doctor
Lordship.
in this background, whether it is a road traffic accident death or not.
Mild. Great.
Total. Next.
I'm for the petitioner, my lord.
Yes.
This matter was heard by your lordship on last occasion, my lord. And my lord wanted to know the investigation and the point of suicide note, my lord. And the translation
Report
of
has
the,
been called for, the IO has filed a report, and he has also, after the order was passed, my lord, he filed an application for investigation, a further investigation. Further investigation order was allowed by the learned ACGM. Further investigation has been
Very
done.
curious.
Yes, my
isn't
lord.
it?
Further investigation done. 161 statement recorded of the complainant, the mother of the deceased, and also a notebook of that deceased has been recovered. Both has been sent to the handwriting expert. Now, from the 161 statement, the state, because the drafting of the complainant is in English and she has signed in Hindi, there is every doubt regarding at the time.
Even if it
And
is
if
in,
name is not there, who has written the complaint?
even if it is in Hindi, whether it is in the hand of the deceased or
Yes,
not.
yes, he has admitted, my lord, now. In
Where is
161 statement, my lord.
who admitted? Only FIR, she disowned it.
And moreover, the articles were seized, the money bag, the bags, all used articles. His parts was seized from the house of from the room of the deceased, my lord.
Nobody disputes that the deceased.
Yes, my
We
lord.
had a visiting come, my lord.
And what was actually another thing she was about it, and in that also paper, as a parents, the name of this petitioner was there.
Correct. He had close, intimate, physical relationship with the
I've
deceased.
translated the the suicidal note into English, my lord, as per the order of the court, my lord.
Give us a copy. Sir, give us a copy.
How correct it is. In every Hindi medium school, there is in Nepali medium school, there is a subject Hindi, my lord. Even I am from Bengali medium school. It doesn't mean that we cannot write in English.
You've never said no, he says that this is not in my daughter's handwriting.
Well, just see the FIR, my lord, it is written in English, yes, I know it. There is no note of who has written the FIR, whether it was read over to him or her or not, my lord. My lord, I know that is the prosecution's at this stage. my lord.
Niloy Chakraborty, you are not appearing for the defense.
My lord, I know that.
Then, if there is
My lord,
this
it is
sort of a
against me, but at
lacuna,
this stage, my lord.
then why should he go into custody?
But this colonel, maybe he is a military person, my lord.
We are
he is
not
a
convicting him.
But even then, my lord, his involvement is there, my lord.
God knows.
If the
Even if, let us say, what is the involvement? There is a relationship between this petitioner and the deceased. There is relationship between the petitioner and Niranjan. Right?
my lord.
And there may be a mental stress because of the deceased herself two timing these two persons.
Hmm.
And in this situation, she commits suicide. She leaves behind a purported note on which there is lack of clarity whether it was written by her hand. Further investigation in this area does not require custodial interrogation, but forensic analysis.
My lord,
So
then-
why should we take
My lord, then,
liberty at this?
my lord, in that case, my lord, let me wait for the handwriting expert, my lord.
Let the handwriting
My
expert
lord.
come.
Because it's an.
All right. His earlier applications were not pressed.
Yes, Lordship.
Petitioner is a member of the armed forces. He contends he developed close relationship with the deceased, with the victim girl, victim lady. However, no, victim lady. However, victim also had intimate relationship with one Niranjan ki?
Niranjan Kumar, my lord.
Niranjan Kumar. She died under unnatural circumstances at her residence. Petitioner has at her residence. Petitioner in the FIR, where is the case diary?
Remember annexed with 16 of our petition.
in the FIR, the FIR was registered on the basis of mere suspicion, and the de facto complainant, that is the victim's mother, disowned the purported suicide note, wherein petitioner purported suicide note. Prayer for anticipatory bail had been withdrawn, had been filed earlier, which came to be withdrawn as not pressed. Presently, petitioner charge sheet presently, petitioner apprehends arrest and has renewed his prayer. Learned lawyer, in this backdrop, a learned lawyer for the state contends petitioner had petitioner had physical relationship with the deceased. He subjected her to mental, she got pregnant and petitioner got her aborted. She was subjected to, petitioner was seen at her residence on the day of occurrence. Petitioner's vehicle was seen standing in front of her residence on the day of occurrence. Suicide note.
Army vehicle, the Shukna is the core command, my lord. In
Mr. Aniruddha বিশ্বাস, FIR says it's the petitioner's vehicle. So if you want to improvise it, during trial, try to improvise.
CCTV footage, my lord, his movement was taken. It's in the pen drive. His movement was very clear.
He had gone to the house. There is ample evidence. The suicide, further investigation with de facto complainant admitted that he had inadvertently claimed that suicide note did not belong to her daughter. Was not written by her daughter. Further investigation on this point is pending. We have considered the materials on record in the light of the aforesaid submission. Deceased had intimate, petitioner is an army personnel. Deceased developed intimate relation with him. It is contended she became pregnant and aborted the unborn child. Petitioner was in the medical papers. Petitioner was shown as her guardian. It has also come to light that the deceased had intimate relationship with one Niranjan Kumar. Full stop. On the fateful day, she committed suicide. On the fateful day, she died under unnatural circumstances. Postmortem report shows an oblique, non-continuous ligature mark high up on the neck, which is indicative of suicidal hanging. Full stop. A suicide note was found in her residence, in her room. In the suicide note, petitioner, she blamed the petitioner for compelling her to take her life. But in the first information report, her mother disowned the said note. On the other hand, she alleged petitioner as well as Niranjan Kumar used to visit her and visit her daughter. There was altercations between her daughter on the one hand and the aforesaid persons on the other hand. She suspected the roles of both these persons in abetting her daughter's death. Full stop. Relying on the suicide note, initial charge sheet was filed against the petition. Presently, further investigation has been prayed to clarify why the victims presently further investigation has been prayed and allowed by the jurisdictional court. During further investigation, de facto complainant claimed due to inadvertence, she stated that the suicide note is not her daughter's. It was not written by her daughter. The note has been sent for examination by a handwriting expert and opinion is awaited. In this backdrop, we are of the opinion it would be premature to reject the prayer for anticipatory bail and reject the prayer for. In this backdrop, we are of the opinion further investigation, which revolves around forensic examination of the suicide note, does not require custodial interrogation. It would be premature prior to receipt of the report for handwriting experts report. It would be premature to reject the prayer for anticipatory bail. Accordingly, we direct the matter be placed for hearing. 4 weeks hence, you will get the report. Handwriting experts report be filed on the adjourned date. Petitioner shall not be arrested in connection with this case for a period of 6 weeks or until further orders, whichever is earlier, on condition that he reports to officer in charge so and so once in a fortnight. All right, they are not to be arrested, but no report as and when necessary. If your handwriting is necessary. Because the constable, this were we were not very sure whether he was. I know. Difficult, yeah. Maybe because what was the charge? Or was he new? Otherwise, this guy doesn't. Here is a very deadly situation. Was responsible. And what he is having 2 affairs and he's under stress. Next. So तो कंसेशन दे रहा है इसके साथ. Nature of injury.
Lordship, three victims have been assaulted. Nature of injury is simple to be confirmed with expert opinion.
We have considered the materials on record.
Head injury.
Allegations of assault are general and omnibus. 7 and 8. Who are 7 and 8? Accused number 7 and 8 assaulted.
Lordship, 1, 2, 3, 4,
All
5,
right.
6, 7, 8,
Injuries,
and 10.
injuries appear to be simple. Accordingly, we are inclined to grant answer. Next.
23.
23.
The allegation of the section 316 to 318, 336, 338, 340, 341. complaint lodged by the partner of a partnership firm against the principal partner and the office bearer. The present petitioner is the office bearer.
Principal accused person is on bail, my lord. Please.
We have considered the materials on record. The instant case arose out of dispute amongst partners. Petitioner is an employee of the partnership firm, keeping in mind the nature of allegations, which has a civil profile, and the extent of the petitioner's complicity. We are inclined to grant answer. Next,
I am for the state, your lord.
hot altercation. How much injury you caused?
Grievous injury is there.
Let us see the injury.
Grievous injury is there, my lord.
Petitioner also has grievous injury. Where is the injury report of the petitioner?
Several rib injuries there, my lord.
Then where is 3 ribs you have broken?
Yes, my lord.
Then
Injury is grievous.
who has been granted? You are the person who assaulted. That's why.
Eyewitness,
Nepal Das and Bancharam Das. Where is the FIR in this case?
page 2. Moreover, my lord, 161 statement of eyewitness is there. my lord.
All right. Who has been granted ancillary bail? Shita. Huh?
You have annexed? Josna.
Huh? Shita is an ancillary bail.
Shita and both are female.
But Shita is the person who assaulted as per FIR with a iron rod. Then
They accompanied with this petition.
who accompanied? What is the FIR saying? উক্ত 3 নম্বর বিবাদীগণ হাতে লোহার রড নিয়ে আমার পিতার কোমরে সজোরে আঘাত করে। Then petitioner's content, there was a free fight. They had also suffered injuries. Case and counter case were registered. They had also suffered injury. Who accused Shita Das and Josna Das. Shita Mistry and Josna Das have been granted ancillary bail. We pray for similar relief. Learned lawyer for state opposed the prayer. He contends injuries are grievous. Co-accused who have been granted ancillary bail are women. We have considered the materials on record. It is contended there was a free fight. Case and counter case were registered. Though injuries are grievous, specific overt act of assaulting the victim with a iron rod is leveled against co-accused Shita Mistry, who has been granted anticipatory bail. Allegations against the petitioners are general and omnibus. Keeping in mind the aforesaid circumstances, we are inclined to grant anticipatory bail. What will you do with their custody? In a case of assault, you have got eyewitnesses. Go and prove it.
I'm good.
Next.
Worship, in item number 25, I beg to appear on behalf of the petitioner.
Yes.
Worship, allegations under section 329, subsection 4, section 64, section 115(2), section 351(2), and section 3, subsection 5 of the BNS. But allegation is this: the petitioner took away the victim with the assurance of better job allegation. Thereafter, she was ravished there, and after coming back to home,
In lieu of job, she was taken and committed rape by the petitioner, my lord.
but what she has stated that on 6th December, 7th December, she was I went to his house, went to her house and abused. But Lordship, I have taken an alibi that I was not here. I was in Jaipur and on those days. My instruction is that my lord, some dispute arose in between them regarding some remunerations. Thereafter, this case.
What do you do?
But
Huh?
I also work in I also work in a hotel as
Waiter, my lord.
my family members are also implicated. They have been granted anticipatory bail.
It's not a case of trafficking. They were staying together.
Consent,
it-
one consent she has gone.
No,
And-
not on consent. She was given an impression she would be given a job. Or like give notice to the victim.
Well, I am for the defendant.
Huh?
I have objected.
Yes, we heard you. Petitioner contends that victim is a major lady. She voluntarily accompanied him to Delhi, where to Delhi. She resided for some time. Thereafter, she returned home and falsely accused him of abduction and rape. He prays for ancillary bail. Learned lawyer for the state opposed the prayer. Learned lawyer for de facto complainant also opposed the prayer. We have considered the materials on record, including statement of the victim. In her statement, the victim said that she accompanied the petitioner on the false promise of giving employment. Then petitioner confined him and resided for 7-8 months, full stop. She somehow escaped and came to her residence, full stop. The victim is a major lady, full stop. She had accompanied the petitioner on the expectation of employment. Whether the petitioner had, she could not be, she remained unemployed and returned home. In the interregnum, it is alleged petitioner had raped her, full stop. Credibility of the said submission, credibility of her statement requires to be assessed in the light of the petitioner's claim, petitioner's defense that the association was consensual. In this backdrop, we are of the opinion custodial interrogation for progress of investigation is not necessary, but petitioner requests to cooperate with investigation, meet investigating officer once in a week.
Grateful.
Repeated once in a week, just for the inconvenience of the you understand? This is the same thing. You understand what has happened. Yes, pass over, man.
Item number 8.
But then government employees should be less. Yes, NDPS, anything beyond co-accused statement? No. We have considered the materials on record. Petitioner is in custody for 35 days. His complicity transpired from statement of co-accused before police officer, which is inadmissible in evidence. During his custody, no legally tangible evidence has transpired, incriminating evidence has transpired. Under such circumstances, petitioner has been able to rebut statutory restriction of 37 of NDPS Act and may be enlarged.
My lord, personal
Grateful.
appearance of the officer may be dismissed.
Noted, dispensed.
Grateful.
Item number 10.
10.
May it please your lordship. Here, my lord, we are in custody for 2 years and 4 months. My lord, there are a series of orders by the Honorable Coordinate Bench. My lord, I have annexed the entire deposition in till that stage, it was till PW 21. My lord, not a witness named me, not a witness. Now, my lord, their lordship
Not a witness?
named me. Now, these 11 petitioners. My lord, just a background, little background. The incident took place on 4th of May 2021. My lord, the father of the the informant, he was assaulted by unknown miscreants. He was taken to hospital, where from he recovered after 8 days. He came back home. He was there in the house for another 6 days. Again, he fell sick. Again, he was taken to the hospital, where he expired this time. My lord, after 19 days, he expired. The FIR was lodged after 21 days. My lord, subsequently, the case was transferred to the CBI as those batch of cases under the post-poll violence. My lord, subsequently, as your lordship is well aware, CBI obtained a stay. My lord, the trial got delayed. Finally, that was vacated. The application, their application for transfer by the Honorable Apex Court was dismissed. Now, my lord,
how many more eyewitnesses?
No, none left. Eyewitnesses examined. My lord,
Mr. Mojumdar, the eyewitnesses have not implicated the petitioner.
now,
Who have been implicated?
Yeah. Till I have annexed till 21, my lord, nobody into. Now,
No,
comes the mother, wife. My lord, she, if your lordship sees, second page, your lordship.
Where have you annexed it?
My lord, this is after filing. After their
So
lordship.
you should have filed a supplementary affidavit.
My lord, kindly sees one
File a supplementary affidavit.
My lord. My lord, second page, she names only one person. Second line. My lord, this is the. My lord, your lordship. And at the bottom of that page, your lordship sees, she names total that there are 3 others, 4 persons.
How many persons were
11.
identified?
My lord, only those. And 11 are before your lordship.
All right, who are you identified? She has identified all of them.
My lord, the kindly sees. The only assault or any overact attributed to at the top Liton Bhomik and at the bottom, she by face cannot name them. Only Uttam Bormon, Vishwajit Bormon, Liton Shil, 3 more.
She can name 4 of them, and others she identifies by face.
My lord, and this statement comes for the first time in court after 2.5 years.
So what can be done?
My lord, and she admitted in her cross-examination that she neither stated to the police nor even to the magistrate. This is, and the only overt act ascribed to Liton Bhomik. And the other witnesses who depose also say that she did not name anybody before them, the other witnesses of the trial. That evidence is also before your lordship. 7 persons, others she does not name even. Out of 11.
In the 164, she has named these witnesses.
She said no.
Are Baba, what is the 164?
My lord, I have annexed that also. And in the bunch, my lord, your lordship will get, my lord, 3-4 pages later on, Monu Dash,
Not in the petition.
my lord, in that copy.
Page. So you make a 30-page petition and all relevant pages are outside the petition.
No, my lord.
Yes.
So, my lord, 29 witnesses out of their charge sheet, 75 of them have been examined, eyewitnesses examined. My lord, if your lordship sees, only she ascribes their fatal role to Liton Bhumi, and in her cross-examination, your lordship sees the page 3, first paragraph, she admits that this was the first time because she had never stated to the police, not to the CBI, not to the magistrate. The 164 is that this is where I stand, my lord. The complainant, if your lordship sees, the son also, he, that is annexed to your lordship's brief, my lord, page 41, PW 21. The second page, the third paragraph, he admits he is a hearsay witness. He says, subsequently, later I came to know from my mother. So the complaint, this was the only eyewitness, and this is the same. And 11 persons, my lord, we are in custody for 2 years, 5 months. And my lord,
When was your application last rejected?
my lord, yeah. So far as the petitioner 1 is considered, this was not placed on 1st of August 23. And so far as petitioner 2, 4, and 5 are concerned, this was November 23. And so far as the rest are concerned, this is the first time we are approaching your lordship.
Two, 4, 5 was rejected in
My lord, November 23, before the evidence was started.
before the.
Before the
All right. Yes, Mr. Mojumdar.
Lordship, we have prepared a report as directed by the bench. My lord, these petitioners have been named by the wife, that has been corroborated with the son and other witnesses. Submission by my learned friend that none of the witnesses has ever named them is not correct.
Where is the son's evidence?
Petitioner, lordship, son's evidence, our report, my lordship will find at page 11, R2. He lost the FIR, but he was not present at the spot. He clearly says, so out of fear, he was staying with his sister.
That's all right. Page 22 we have seen.
He's PW 21.
Lordship, our report R2 at page 11.
Where is the FIR? In the magistrate, before the magistrate, mother has not named, the wife has not named anyone. So in the FIR, who were named?
Son,
Who, son named whom?
if I take page,
Page 20,
petitioner.
There also nobody is specifically named. The earlier rejection in November 2023, there's a rejection saying that 164 statements implicate the petition.
Other 164 data is has also been examined. He also does not say anything.
Where is PW 20?
I know that.
How many witnesses you want to finish?
My lord, we have fixed 17 to or 5 witnesses. My lord, we lost 6 months because of the stay granted by the apex court. We will finish it within that frame. If we get 6 months, we'll complete it.
What more witnesses you want?
My lord, in this case, my lord, there are two things. There is the local hospitals and nursing homes. They had given a verdict as the cause of death as natural, multi-organ failure. There was no postmortem done.
No postmortem?
No postmortem done. When the CBI, under the direction of the Honorable High Court, took up investigation, these reports were sent to AIMS. Report came back from the AIMS that it is a case of homicide. Clearly, death due to injuries, his base of the skull was fractured. He was shot in the eye with an arrow. His right ankle was hacked. AIMS said he died because of these injuries. Septicemia. And my lord, these petitioners have a very deep criminal antecedent. There is a statement by one of the co-accused and 27 recovery is there for preparing explosives. That Litonshil had led the CBI to the spot where Uttam Bormon.
What are the antecedents of this?
My lord, we have annexed it in our report, my lord.
Page 24,
there is no evidence of recovery.
Page 24.
It will come, don't worry.
Page 24. আমাদের রিপোর্টে page 24.
Lordship, page 24.
Liton Bhomik.
Liton Bhomik, my lord.
Liton Bhomik has.
Liton Shil is the main.
Liton Shil has criminal antecedent.
Liton Bhomik.
Liton Bhomik also has criminal antecedent. And Uttam Bormon also has.
Uttam Bormon Bishwita.
Shanur is there.
9 out of 11 has a very deep criminal antecedent.
No, we are seeing Liton,
Liton,
Uttam, Liton Bhomik, Liton Shil and Uttam Bormon. And Shahanur. Apart from that, anyone has any criminal antecedent? Oh.
Ratan Rai, Vishwajit Bormon, Robikul Haq, Ramjan Ali.
Anar Hussain is there. Sujan Pranab Barkayat.
Sujan Barkayat has criminal record.
Ratan Rai. নকুল রায় কিছু নেই, উত্তম বর্মন আবার, বিশ্বজিৎ বর্মন দুটো, রবিউল হক। হুম, no, it's a different. In Hada, and here in Sadar there is one. Because you will find your main grievance is Uttam Bhomik, Uttam Shil. These are the, sorry, Liton Shil, Liton Bhomik,
Uttam Bormon, Osman Mia.
Utman and Osman.
Osman shot the arrow.
That evidence is not coming.
The wife says.
No. It comes from the son's statement that the wife claimed Osman shot.
Yes.
But in chief, she says that one person shot the arrow. And if you see the 164, she was not present when the arrow was shot.
My lord,
He comes
Yes, my lord.
after he's lying there with the injury on the eye. And then the assault starts, of which the main principal player is Liton. Right? So far as Osman is concerned, their presence is noted, but to what extent they participated is not very
my
clear.
lord, kindly consider.
Clarity is there with regard to Liton Shil and
Return Bhomik,
Liton Bhom.
Uttam Bormon.
Uttam is also there.
Yes, my lord.
No.
Statement.
Assault. Accused Uttam Bhumik took out the knife. He cut. And there is another thing about Uttam Shil also. Real. Liton Bhumik assaulted.
Cut the angle of the right leg of my hand. Yes,
Before 164 statement, before the CBI, did she name these persons? Let us see what she.
No, so she did not state anything to CBI. It came out during investigation.
Now the other witness is PW 23, who has been declared hostile.
Lordship.
The impact, but he admits the 164.
He admits the 164.
He admits the 164. And in that 164, who are named?
Get one of the last 3 pages of that part. So there is second page middle. Ramjan Ali, Liton Shil, Liton Bhomik.
No, my lord, he, Shopon Bormon is 164 has said, Osman Mia through the arrow.
The middle of second page of this 164.
Read it.
শ্রীধর মাটিতে পড়ে যায় এরপর একটু ফটো পিকচার রমজান আলী ও রঞ্জন আলী লিটন শীল লিটন ভঙ্গি শ্রীধর ও তার স্ত্রীকে লাঠি দিয়ে মারতে থাকে এই লিটন শীল লিটন ভঙ্গি এন্ড রমজান
Chirku, who is Chirku?
That is a pet name or the petitioner.
Which petition?
I will just find it out, my lord.
Ramjan. Robiul.
লিটন শীল লিটন ভঙ্গি
My lord, if your lordship kindly goes a little up upwards in the written statement. আমি হঠাৎ একটি
বোম পড়ে।
পড়ে আতঙ্কে পালিয়ে গিয়ে একটি দোকানে আশ্রয় নিলাম। আমি সেখান থেকে দেখতে পেলাম ওসমান নামে একজন শ্রীধরকে তীর মারে।
Not a petition. So the main allegations are Uttam, sorry, Liton Shil, Liton Bhumik, Uttam Bormon. Uttam Bormon.
It does not name Uttam. It does not name Uttam. It says Chikru,
Chikru is
9, Robiul.
Robi,
They asserted the Lati after the incident.
Robiul and Ranjanal.
আরেকটা copy। আমি কি বলবো?
But this he does not state in its chief.
If he proves the 164, then
Now,
Robiul, Ramjan Ali, Robiul, Ramjan Ali, then Liton Shil, Liton Bhumi, and Uttam Bormon. Sure, take them.
My lord, and further, my lord, if your lordship permits, my lord, I am also banking my case on a recent judgment of the apex court, where the apex court was pleased to hold that once this is involving 302 rape, once the trial starts, High Court should load to grant it.
Yes.
My lord, perhaps knows the judgment, X versus State of Rajasthan.
We also know other judgments where the
Yes,
high
but
courts have
absolutely, my
not
lord.
been low.
And my lord, our opposition is mainly on the ground, they're very influential persons.
That we will see.
Because they have
Their control and influence will be restricted. We are not granting bail to all. The persons who are just identified in court by PW 21, the eyewitness, and the persons whose name appears in the 164 of the other witness who, while admitting to the 164, did not support it in court, we are not at present granting bail to them. Uttam Bormon, Liton Shil, Liton Bhomik, Robiul Haq, and Ramjan Ali. We are rejecting the application. Name is there, is named, we are not going to give. Others were just identified.
At the bottom of that page, he was nothing more, no.
My lord, I would only request your lordship to see the criminal incident of other people. Rokul Rai has got many cases against him.
But then if there is nothing against him in this evidence, what will be? Even PW 23 in his statement before magistrate does not name him. Right? So we will put these persons on conditions, they will not be inside Kuch Bihar, district of Kuch Bihar, and they will face the trial. And more importantly, vulnerable witnesses have already been examined. So no chance of winning over witnesses, isn't it? Petitioners are in custody for 2.5 years. 2 years, 5 months. Some of them some of them, that is,
Picture number 241, 245. Separate. One was not pressed, 245.
Prior to recording evidence, petitioner number, first petitioner, first, second, fourth and fifth petitioner had approached this court earlier. Prayer for bail of the first petitioner was dismissed as not pressed, whereas that of second, fourth and fifth were turned down by a coordinate bench. Referring to the evidence on Mr. Meter contents the contents, most of the witnesses have been examined, referring to their deposition. He refers to the, he submits none of the witnesses apart from PW 21 has, apart from PW 21 has, he submits none of the witnesses have implicated the petitioners in the crime. PW 22, who claims to be an eyewitness, named fourth, failed to name the petitioners apart from the fourth, fifth, first, fourth, fifth, and eighth petitioner. And eighth petitioner in court, full stop. The other petitioner, she had not, the others had not been put up for identification by the said witness during investigation. Now, though not named by her, no TI parrot examination was undertaken, and they were identified for the first time in court. Apart from the fourth petitioner, no overt act is attributed to the others. Fifth petitioner, no overt act is attributed to the others in the crime. Prosecution proposes to examine all the vulnerable witnesses have been examined, and prosecution proposes to examine 30 more witnesses. All vulnerable witnesses have been examined, and prosecution proposes to examine 75 witnesses in all. There is no possibility of trial concluding in near future. You go on pruning. You have not indicated how many.
17th and 18th day will be examined 5.
5. Very good. Very good.
Around identification, we will drop it.
Accordingly, they pray for bail. Deputy Solicitor General opposes the prayer. He contends the petitioners, most of the petitioners have criminal antecedents. Full stop. They are dangerous. They are dangerous persons belonging to and have political patronage. Full stop. Initial investigation by the state police was aborted through influence. Even the PM report even the initial PM report indicated death due to due to their influence, no postmortem was done. However, medical papers collected during on analysis of medical papers collected during investigation, doctors attached to AIMS opined that the death was homicidal. Full stop. PW 21 is a 22 wife of the deceased is an eyewitness. She identified all the petitioners as members of the group who assaulted the victim. Full stop. Charge is one of 149. Charge is one of constructive liability. Charge is one of sharing common object of of being a member of an unlawful assembly which shared common object to murder. Her evidence is supported by her son, PW 24, PW 21, full stop. Though PW 23 was declared hostile, he admitted his statement before magistrate. Full stop. Accordingly, he opposes the prayer. We have considered the evidence on, we have considered the materials on record, including the evidence. Full stop. PW 23 is, PW 22, wife of the deceased, is an eyewitness. She, however, admits she could not name the assailants before CBI or the magistrate. In court, she implicated the fifth assailant. Her statement before magistrate shows shows she arrived at the spot after the victim had been shot, after an arrow had been shot at the victim. Full stop. She saw the thereafter she saw the assault on her husband. She was also assaulted. Full stop. In court, she attributes assault by knife to the fifth petitioner. She also names the first petitioner, fourth petitioner, and the eighth petitioner as members of the unlawful assembly. However, the other petitioners, that is so and so, so and so, however, with regard to other petitioners, she identifies them by face. Full stop. She identifies them by face. Full stop. However, she identifies them by face. Their identification, she identifies them by face for the first time in court. The case is for the first time in court. The involvement, possibility of their implication in court for the first time in court. No corroborative evidence with regard to prior identification in course of TI parade is placed on record. Quality of evidence is placed on record. Credibility of such identification in court deholds prior identification during investigation of unnamed accused may be done in course of trial. May be done in course of trial. Deputy Solicitor General rightly argues that some of the unnamed accused, namely Robiul, Kirku and another is Ratan. Some of the unnamed accused, namely Osman, who are the other unnamed accused? Just, no, sir, you're 164. Very good. Kirku is Robiul Ranjan Ali, right? Ramjan Ali. Acha. Some of the unnamed accused, namely Robiul and Ramjan Ali. and Osman Ali as the miscreant who threw the who shot the arrow, bracket closed, dash not before this court, bracket closed, are referred to in PW 23's statement before magistrate. Mr. Mitro contends the said witness has been declared hostile. Be that as it may, the witness, Mr. Mitro Korna, though the said PW 23 is declared hostile, comma, the said witness admitted his statement before magistrate, implicating the first petitioner, implicating the fourth petitioner, fifth petitioner, ninth petitioner, and 11th petitioner as persons, as members of the unlawful assembly who participated in the assault. Full stop. We are conscious of our remit in a bail application involving a case of group murder. In such cases, involving group violence resulting in murder. In such cases, it is not the duty of the court to sift the evidence, in the midst of trial, but midst of trial. In such cases, while in such cases, it may not be prudent to sift the evidence where each accused in midst of trial, comma, it is equally important to bear in mind the possibility of politically partisan witnesses casting net too wide to implicate large number of accused in the crime. Added to it is the issue of protracted detention, which in lingering trials as the present one, it may not be out of place to bear in mind the petitioners are incarcerated for for more than 2 years, and a significant portion of a part of the delay was on the score of the prosecuting agency approaching the apex court for transfer of proceedings outside the state of West Bengal. Full stop. In this premise, we have addressed the prayer for bail not only from the prism of not only from the prism of culpability, on the prism of gravity of the offense and the culpability based on evidence on record, but the possibility of but the issue of protracted detention infracting fundamental right to speedy trial of the accused against whom scanty and legally fragile evidence has been adduced. Taking into consideration these aspects, we note the implication of the second, third, sixth, seventh, and 10th petitioner is based on the bold identification of the is based on their bold identification that they were merely members of the unlawful bold identification for the first time in court by PW 23 at the bold identification of their presence PW 23's bold identification for the first time in court. Full stop. No specific overt act is attributed to them either by PW 23 or even in the statement before magistrate, even in PW 24, force bracketed hostile witness statement before magistrate. Full stop. Hence, a statement before magistrate. However, PW 23 has specifically named PW 23 in her deposition has specifically named petitioner, first petitioner, fourth petitioner, fifth petitioner, and eighth petitioner as members of the unlawful assembly, and stated the fourth petitioner had attacked her husband with a knife, causing severe injuries and ultimate death. Her statement, her deposition is corroborated in PW 24 statement before magistrate, wherein he specifies the role, wherein he refers to the role of the fourth petitioner, fifth petitioner, ninth petitioner, and 11th petitioner in the assault. Full stop. A summation apart from the said, these incriminating evidence clearly show these incriminating pieces of evidence support the prosecution case, put the prosecution case on a more sturdier plane in respect of the aforesaid petitioners compared to the on a sturdier plane in comparison to the other petitioners before us. Accordingly, other petitioners before us. Mr. Mojumdar has also argued that some of the petitioners have criminal antecedents. Accordingly, we are inclined to grant bail to petitioner number, second petitioner, third petitioner, sixth petitioner, seventh petitioner, and 10th petitioner, but reject the prayer for bail of the other petitioners, namely so and so, so and so. Mr. Mojumdar, at this stage, Mr. Mojumdar argues that the 10th petitioner that the second petitioner, Pritom Rai, seventh petitioner, second, seventh, Ratan is before us. Third, 2nd, 3rd, 7th, and 10th. নকুল কত? 6th. 6th and 10th petitioner have criminal antecedents. We have examined the nature of antecedents of the said petition. Oh, sorry, নকুল no record. ওই 6th থেকে কেটে দাও। Yes, but in where? Which PSCS case? There is no case in Shodor, neither in Dinhata. That is what. Have criminal antecedents. However, the evidence, however, as discussed above, the evidence against the said petitioners with regard to their membership of the unlawful assembly and roles and specific roles is most sketchy. They have been in custody for a protracted period and there is no possibility of trial and as prosecution proposes to examine 79, more than 70 witnesses, there is no possibility of trial concluding in near future. In this backdrop, in this situation, we are inclined to enlarge the said petitioners on bail. However, subject to strict moreover, all the vulnerable witnesses have been examined and there is no possibility of winning them over. In this backdrop, while granting bail, while acknowledging their right to bail on the ground of on the ground of protracted detention, we propose to impose strict conditions so that their movements are restricted and the confidence of the witnesses are in no way, and there is no possibility of the said petitioners indulging in violent activities in future. Indulging, কি বললেন যেন? Interfering with the administration of justice, criminal justice. The petitioners shall be released on bail on furnishing bonds of 20,000 with 2 sureties of like amount, one of whom shall be local, and on condition that they shall not enter the district of Kuch Bihar. Kuch Bihar, na? This is Kuch Bihar? Dinata is Kuch Bihar. Kuch Bihar, except for the purpose of attending the trial in the present case or any other case, and shall provide the address where they shall reside and shall report to, do you have an office outside Kuch Bihar where they can report regularly? And to Siliguri, they will report to so give the who is the head or whoever they will report to. So and so DSP once every week until further orders. Would stop. We request the trial judge to conclude the trial at an early date. Ask your junior to sit with our officer and indicate. What we have done is persons who have been named by PW 22 and also in the statement of PW 23, we have not given them. Others, we feel identification unnamed for the first time in court without corroboration. The quality of evidence is sketchy with regard to presence and there is zero role. So we have enlarged them on bail and we have kept them because of your allegation of criminal antecedent outside the district.
Certainly, that I also understand, but I cannot see it any.
হ্যাঁ রিজেক্ট আটটার নামটা কি art is rejected. Vishwajit Burman is named by PW 22. দেখো এভিডেন্স গুলো আছে ওখান থেকে কমপ্লিট yes Mr. Singhani please help the officer. Yes, next matter. Naturally it was supposed to be a supplementary affidavit. STURDI. Yes, next matter. Four. Osman আসেনি। Supplementary affidavit enclosing the judgment is placed on record. Appeal is admitted, issue usual notices. We are rejecting the bill.
Cross examination, kindly see once.
Let him say,
The petitioner is 18 years old.
So,
Kindly see one, sir.
give notice to the victim. Thursday, victim be noted. Next.
I am for the appellant. I am for the defector.
Yes.
Lordship, there is a bail in connection with appeal. Lordship, the petitioner is the mother of the principal accused. Allegation against
What
her.
about the principal accused?
Lordship?
What about the principal accused?
Principal accused, I have not preferred this bail application, Lordship.
So we give the mother. You have considered the evidence of the evidence on record. Appellant number
2, Lordship.
Appellant number 2. Applicant is the mother of the principal accused. In view of the, she has made out an arguable case in appeal, keeping in mind the aforesaid fact and the extent of her involvement, we are inclined to suspend the sentence. Paper books, PCR, right? Appellant number 1, that is principal accused, has not prayed for suspension of sentence. TCR has been received. The paper books be prepared within 8 weeks of receipt of TCR. Next.
I am acting for the appellant, my lord. Now, this is a matter, my lord, which is, my lord, under section 6 of the Protection of Children.
Victim notified.
My lord, yes.
Notify the victim Thursday. Other matters 2 p.m.
Thursday.
Thursday. Admission of other.
Lord, I'm for the state. Milord has directed service upon the victim, Milord. That has been done.
29.
Yes,
Huh.
Milord.
Service done.
Yes, yes.
How many days delay? Service, where is the report? Service report is placed on record. Nobody appears for the victim. We have considered the averments in the application for condemnation of delay being satisfied. Appeal is admitted. If usual delay is condoned, appeal admitted. Call for trial court records. Issue usual notices. Liberty to pay for suspension of sentence upon notice to the state through public prosecutor and upon victims to register speed prosecutor.
Great.
Next.
Get a copy of the judgment that because the record is lying to your lawsuit. Okay,
Huh? Oh.
Last time we
Take a, making a photocopy. You take the photocopy. When should we keep it? You have to file it. Do you want to file a memo too?
already applied for, but the record is lying to your lawsuit.
He'll make a photocopy and give it. When can you file the petition of appeal?
I have filed the application before the concerned office on 16/12.
Arey, when are you going to file the petition of appeal?
Actually, I have been appointed on 26/11.
We are giving you the photocopy of the judgment today. When can you file your petition of appeal, delay appeal? Friday. Next. Hey, ওনাকে photocopy করে দিয়ে দাও, Mr. Bhowmikকে photocopy. An evidence copy you have got? That you can get from there. Hey, applied, how would you, when will you get applied? Next.
Lord, I am for the de facto complainant, Lord.
Notice has been served, Lordship, by the
Lord, only intimation has been given. I need a copy, Lord, to respond to the, though it is at the admission stage.
No, who is for appellant?
Mr. Jonardhan Periwal.
He is not there.
He was there in the morning, Lord, but now I can't see.
There is a delay application.
Cran 1.
Copy of Cran 1 be served upon Dr. Chaudhary. Matter will appear. Next available circuit.
I'm grateful.
Next. (32).
Lord, I am for the appealing.
Delay.
The delay was condoned on the last occasion by your lordship.
Then
There was a direction to serve upon the, serve to the DSG office, your lordship.
for what?
So this is an appeal from conviction.
So,
I have served the,
and served what?
served the entire copy of the appeal with the annexes, my lord,
So,
as per the record.
who's directed you to serve copy of the appeal? The copy of the application was, any can is there?
Can is disposed of, my lord, on the
Okay,
last
disposed
occasion.
of. Nothing is disposed of.
So there is a delay of 33 days, my lord. In
So
filing the
where
appeal.
is the delay application?
The delay application is can 1, my lord.
Can one, Mr. Singhania, sir?
Lordship, copy was served to the DSG, but this is the matter of customs. One
So?
Raton Bonik impaneled, your lordship.
That's your headache.
Lordship,
Head doesn't know where the neck is, where the hand is. You are in charge of the office of the Deputy Solicitor General. Wherever, whichever central agency is there, you have to send the papers.
Lordship. Send the-
Someone will not run after your agencies.
Lordship,
You are the nodal body.
Lordship,
Tomorrow,
Lordship, we intimate.
As your lordship pleases.
you are not even aware of the case. Where is the condonation?
Condonation of delay application is there, my lord. Can one, my lord.
Correct, but where has it been delayed, condoned? Where the delay has been condoned?
My lord, on the last occasion, my lord,
See the order sheet.
as you know.
The orders come up online, don't they?
Yes.
Then least that you can do is just check the orders. Next.
Yes, 33. Is the admission or appeal, my lord?
Admitted issue usual notices. Call for trial court records, liberty to pay for suspension of sentence upon notice to the state. To public prosecutor, High Court, circuit bench. Next.
My lord, I am for the appellant, my lord. This is, my
In
lord,
time informed,
in time, my lord.
same order.
I'm grateful.
Next.
I am for the petitioner, lordship, the restoration application.
Yes, what is the
The co-accused standing on the same footing granted bail by your lordship.
yes, who is for state?
Showed up. 665 days custody, your lordship, ADPS Act, 11 bottle of penicillin and
Not yet served, lordship.
no, no, sir,
Upon me.
Take instructions tomorrow? Tomorrow. Next.
Lordship, I am for the petitioner, lordship. A certified copy need to submit, lordship. Lordship.
On the prayer of the petitioner, next available circuit bench.
Grateful, lordship.
Next.
I'm grateful to you.
My lord, I am for the opposite party, my lord. My lord, I have just received the copy of the petition in the morning. Kindly allow us to give the opposition.
After an opposition
It will be
within
served on 24th.
within 4 weeks. Reply 2 weeks, matter will appear 7 weeks hence.
Thank you, my lord.
Lordship, only kindly adds one line, affidavit of service filed.
Evidence service is placed on record. For Deputy Solicitor General, for CBI and so on and so forth. Next matter. Nobody appears. Next available circuit.
I am for the appellant. If this matter be placed before next circuit.
Next circuit.
Grateful, lordship.
40 that is proven.
Next.
40 minutes. I appear for the appellant, my lords. Very thankful, but from the last occasion, my lordship had given it a very patient hearing. So there are just a couple of things, my lord, I would like my lordship to take through.
Yes.
First of my lords, from the paper book, my lords, if I can have my lordship for a moment, on page 47. This one, my lords. The voluminous one. Page 47 is the assessment of the report of blameworthiness, my lords. What was the blame against me? Page 47 says, my lords, that after analysis of the record of evidence, which is, my lords, the ROE,
of the statement of witnesses and taken into consideration the circumstances of the incident and the corroborative evidences, inquiry officer is of the belief that you and I such and such, name such and such, is blameworthy of intentionally cocking the rifle in his possession with an intention to develop a state of domination over ASI such and such. So that was the only charge against me. There was no charge of attempt to commit any suicide, or there was no charge of showing any kind of a threat or intimidation to the superior officer. This, my lords, followed by the finding of the court. The opinion of the court is at page 53, my lords. And the recital at page 53, my lords, just after the opinion, it says, after careful examination of the statements, questionnaire of witnesses, and examination of relevant documents and exhibits, and taken into consideration the circumstantial and corroborative evidences, the court opines that, and lords, I am on number 3 opinion. It says, neither the sentry was holding the rifle with the barrel pointing towards his body anytime, nor was the sentry holding the barrel pointing towards anybody anytime, which reveals that the sentry had no any intention of harming himself or anybody else anytime during the incident. So this, my lords, was the opinion of the court against me. Now, from there, my lords, if I can have my lordship for a moment, my lords, on section 86, the section, my lords, is on the other booklet.
Don't have another copy?
My lords, at the last occasion, my lords, another copy was there. I'm so sorry, my lord. It was with the file, my lord. There were two different. I am on section 86, my lords. Section 86, my lord, subsection 2 says, because I already said, my lordship, there are 3 different kinds of court. And SFC is a court, my lords, which has to be convened on a very immediate basis when, my lords, delay cannot be avoided. 86.2, my lord, says, when there is no grave reason for immediate action and reference can without detriment to discipline be made to the officer empowered to convene a petty force court for the trial of the alleged offender, an officer holding a summary force court shall not try without such a reference to be made. In my case, my lords, what happened was, after 1 year and 5 months of me serving the duty after suffering the imprisonment, my lords, without resorting to 86.2, a summary force court was again set up. No additional recording of evidences were done. No COI was repeated. Only, my lords, the court sat for a day and it passed an order which was contrary to the previous order, my lords. With my lord's permission, my lords, I would also like to refer to 105G.
86.2 does not have any, has no relevance to you.
No, relevance is there, my lords, because I suffered my imprisonment at the first occasion.
All right.
After 1 year and 5 months, they could have referred it to the PFC.
All right, the powers are flowing from a supervisory authority, not by the officer who is convening the security force court. 86.2 speaks of the officer convening the security force court, holding the security force.
For that, my lords, I would just like to refer to one judgment of the Honorable Supreme Court. Manohar Lal, my lords, para 23 is of some relevance here. This, my lords, is precisely on the acting under dictation, doctrine of acting under dictation. I'm so sorry, my lords. Para 25 is the paragraph.
It's dictation, not that argument we have followed. Whose dictation, sir?
My lords, it was from the dictation of the DIG.
Yes, the DIG is a prescribed officer under 132, isn't he?
He's a revisional authority.
Is he revisional authority? So if a revisional authority in a quasi-judicial proceeding asks the adjudicating authority to adjudicate afresh, that's doctrine of dictation, Mr. Mishra.
For my
doctrine
satisfaction,
of dictation is completely different. When an authority has not applied its mind, prior to application of mind, A superior authority dictates that authority to act in a particular manner. Here, that authority has acted, and upon perusal of the way in which he has acted, the superior authority felt there are other offences for which the person ought to be tried. Is that dictation or supervision? There's a clear distinction between them.
My lords, just two more sections, my lord.
Yes.
One, my lordship, is my lord's 153. Rule 153, my lords, I'm so sorry.
One five.
153, my lords.
Yes.
It says, my lords, that the court shall award one sentence in respect of all the offences of which the accused is found guilty.
43(6) was not an offence for which you were found guilty for the sentence of 40 days forced custody.
My lords, even the opinion of the court.
Answer is very clear. 43(c) was not an offence for which you were found guilty. Okay.
And then, my lords, just one more section, my lords. One more rule, my lords, 155, and then I will rest my case. In fact, my lords, I previously referred that on the same set of facts, my lords, there should be one trial that should be there.
Yes, where is that?
And in consonance with that, my lords,
Correct.
155,
What provision? Where is that provision?
my lords, 156, my lords. 56, my lords, of the section.
56 section.
Of the section. 56 of the rule, my lords, I'm so sorry. And my lords, I have already said that the annulment, my lords, was not in accordance with law, my lords,
Why?
because the officer who annulled the proceeding was not the officer competent to annul the proceeding.
Why?
My lords, because he is not a person prescribed, or he is not the.
Does not the superior officer inherit all the powers?
No, no, my lords,
of
he
the-
cannot annul. He can set aside, but he cannot annul, my lords.
What is the distinction between setting aside?
In
and
case of a
annulment?
set aside, my lords, the proceeding can be carried mutatis mutandis from the same place where it was set aside. In case of annulment, the entire proceeding goes away.
Naturally.
So the power that has been conferred, my lords, was of set
What-
aside, not of
yes,
annulment.
what-
132, my lords.
Do you have any authority to that effect? That the person in 132 cannot annul?
Yes, my lords.
The
132
132
from
uses the word annul.
132 read with rule 185, my lords.
Sir, 132 uses the word annul.
Annul. But
Yes.
this power was not available with the DIG, my lords. Who can do that, my lords? The central government, the director general, or any prescribed officer.
The
He is
DIG
neither
is
the.
not a prescribed officer?
No, my lords, he is not. As per 185, my lords, he is not. Rule 185. Who will be the prescribed officer under section 132 is described in rule 185, my lords. This person who annulled, my lords, he does not falls within that category, my lords. So my submission before my lordship would be, my lords, that the entire second proceeding was a sham. They wanted to punish me by hook or crook because the superior authority said so.
What are the powers of the DIG?
The powers of the DIG, my lords, will find is 162, my lords.
Of rules.
Of the rules, my lord. And this power, I referred to it at the last occasion also, my lords. He has here two powers, and both of them is in favor of the accused. One is he can set aside, and second is he can reduce the sentence. In my case, my lord, the sentence was not reduced, because the hierarchy of sentences is at section 51. Section 51 of chapter 4, my lords, talks about the hierarchy of sentences, my lords, in the act. It has been arranged in the ascending orders. Sorry, my lords, it has been arranged in the descending order. The harshest punishment is at the top. I am on section 51, my lords.
So
the harshest punishment, my lords, is at the top, and my lords, dismissal from service is at C. So that is the third harsh of all the sentences. And the sentence that was awarded to me in the first instance was at E. So at the second instance, not a harsher punishment was given to me. And the explanation, my lords, is there below. Each of the punishments at 51(2), my lords, each of the punishments specified in 1 shall be deemed to be inferior in degree to every punishment proceeding in the above scale.
So according to you, if a security force court proceeding is referred to the DIG, he has no alternative but to accept it.
Either he can set aside, in that case, court would be again, or he can reduce.
Then set aside, in fact, is annulment. Set aside is in fact annulment.
With respect,
why
lords,
we are
the
saying-
only difference between a set aside and an annulment would be, lords, that in case of an annulment, the entire proceeding goes away. In case of set aside, only the judgment goes away and the proceedings runs from there.
From if a fresh charge is directed to be framed, what happens?
Lords, the previous punishment that was already suffered by me,
That is neither here nor there. Previous punishment said to be in active duty, that has been reversed because of it being annulled. Let us say it was not annulled. Right? Then for punishment for charge A, which is a lesser charge than charge B, for which it was set aside for initiation of a fresh security force proceeding, will it stand in the way of initiation?
then in that case, lords, a fresh blameworthiness and a fresh opinion of court has to be there, which didn't happen in my case.
That is neither, that issue you have not taken up. Your case is clear that he had no jurisdiction to direct a fresh security force court. That's it. In fact, you have not challenged the order of annulment. However, since your contention is that without annulling, there could not have been a direction for a fresh charge and a fresh security force court, we have permitted you to make your submission. And in doing so, we indicate to you that if you see the power, now, if you see very interestingly, the provision that you showed, section 51.
My lordships, 51 punishment.
Sorry, no, not section 51. The power of the security force court.
86, my lords.
DIG's powers.
Oh, DIG power.
Yes.
162 of the rules.
162 of the
162 of the rules is the power of the DIG.
It only speaks of when he finds a defect in favor of the other. But if he finds inadequacy of sentence, if he finds a graver charge not being applied, what does he do? Because there is no confirmation by a commanding officer in a security post court in light of section 120. It is reference to the DIC.
Milords, the argument would still remain, Milords, that after 1 year and 5 months, there was no grave immediate urgency, Milords, that was involved. He could have referred it to the PFC, which was not done in my case. I was in duty after suffering my 40-day imprisonment. I was still in duty.
Our contention to you is what happens after the security post court pronounced
Immediately promulgated, Milords. I showed it to my lordship on the last occasion.
Correct.
The sentence is immediately promulgated.
No, it is referred to DIG. It is referred to DIG.
That is after promulgation, Milords.
So it is promulgated, and that is rule 61.
160, Milords, of the rules. It talks about an earliest opportunity when it should be promulgated. And then, Milords, comes the power of 162.
Huh? 161.
One sixty of the rules, Milord, which would be, Milord, page 68 of 110 in the paper.
Let us see chapter 11. That is
My lordship.
Summary force code.
My lordship. Just a caveat, Milords, 163 needs.
1 second.
My lordship.
1 second.
My lordship.
The review is by the and the review outcome is only everything is done. Something is done to the actually. And so the process is done. What they have done is they have gone for 132. 132 gives power to the superior authority to annul proceedings. The prescribed officer is a commanding officer who is under the DI. Is not the DIG a person?
He's not the prescribed officer, my lord.
No.
As per rule 182.
185.
185, my lord.
Now you come to 185. The prescribed officer for the purpose of shall be an officer commanding a frontier, sector or training institute.
My lordship.
In respect of proceedings confirmed by him. Isn't it? Or by a person under his command. So any commanding officer or anyone under the commanding officer.
No, my lord. He's somebody who is commanding the frontier or a sector. Is not a commanding officer, my lord. Commanding officer is a commanding officer of the battalion. So in one frontier or one sector, there can be 10, 15, 20 battalions.
So the DIG can be a commanding officer?
No, 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 he cannot be.
He is not?
No.
According to you. All right, we'll ask Mr.
Marshal
on that.
Marshal.
The frontier is commanded by the IG,
Yes.
sector by the DIG, and the training institute by the DIG.
You enlighten us on that.
That is the manner. I just asked for if there is any instruction on that, I will file that, but it is that frontier.
No, what Mr. Mishra is indicating is, and he's rightly indicating, if you see 61, 62, DIG's powers are until and unless you can trace the power to an officer prescribed. Now, the judgment under appeal, his honorable single judge has not decided this issue. On the ground, the annulment order has not been challenged. Right? Mr. Mujumdar, I will ask you this question. If the annulment order was not there, there are two ways of looking at it. If the annulment order touches the very jurisdiction of the initiation of the subsequent summary force court, then challenge to the finding of the summary force court would inhere in a challenge of the initiation of the proceeding itself. Independent challenge is not necessary. It's not something where his submission to jurisdiction is an acquiescence to the summary force court. It's a question of
subject matter jurisdiction.
The right subsisting in the authorities to initiate a subsequent. We have heard Mr. Mishra on the question of the subsequent charge being framed. We have also expressed our views on it. It appears to be a different charge. 46C is a 43C. 44C is a different charge from 22. So to really say that it was punishment for the same charge, we are not really convinced. But the question is, could the DIG direct the initiation of the second proceeding? If the DIG did not have the power to direct initiation of the second proceeding, then failure to challenge the initiation, will it confer jurisdiction to that extent?
My lord, basically two questions are bothering your lordship. One is the iota of evidence.
That will come later. That will come later. Mr. Mujumdar, we will not allow Mr. Mishra, and Mr. Mishra very fairly said, we are not going into the sufficiency of evidence. We are arguing primarily on the jurisdiction of the DIG to annul the earlier proceeding where the summary force court had punished me for a charge which are on same facts, and after that there could not have been a second summary force. On the issue that at no point of time there could not be a second summary force court, we are not with Mr. Mishra. If on the facts a graver charge is evident, then naturally the question of unjust and illegalities come in, and the word of all charges on the same facts That is section what? All charges to be tried on the same facts, 132 or something?
156, my lords.
Sir, 156 is the rule. There's a particular
Rule
section.
56 of the rules, my lord.
Mr. Mishra, help us with list of rules that you
We
are
will do
referring
that.
and with the points.
We will do that.
Because we are not really.
We will jot it
don't
down in
remember
a ascending
the
order, my lord.
sections and rules by heart.
My lords. 56 is, my lords, the rules.
That 56 is, you also,
My lord,
you are not. Where is the provision that all the charges are to be leveled together? वो जो 56 का रूल है, हाँ, that's the thing.
ये विदुर पूर्ण बदल दिया।
Rule 56.
56.
You give us.
I'm sorry, my lords.
No, not sorry.
No.
We are sorry. Please.
No.
Give
I
us-
will arrange it in ascending order, my lords, of the acts and of the rules, and also which act corresponding to which rule. I will do that.
What's that? Here the word is may. Section 50, rule 56, the word is may.
So what is shall, my lords? A charge sheet shall contain.
Oh, sir.
Oh, I am so sorry, my lords. May contain more than one charge.
So our thing is shall contain the whole issue or issues tried in one time. Very good. But if it does not contain one charge, it can have supplementary charge sheets and also amendment.
That is also there.
Let's not jump.
My lordship.
And also amendment during the summary court
Yes.
proceeding. What happens when these exercise is not applied to by the officer
Holding the FS.
holding the FS,
My lordship.
and it comes to the notice of a Director General? Can he not say the summary force court is illegal? There should have been an amendment, and therefore I annul the proceeding and I direct a fresh summary force. Question is whether DIG could, as a commanding officer of a sector or training institute where the person in respect of which the proceeding he was conferred, if he can do it, then the annulment issue is addressed. And the second issue falls out. This is the question.
So apart from 132, DIG has also power to set aside under rule 160.
Oh, sir, that power is in favor of the accused. Just see 160.
My lord, I have this instruction, but I have now I have asked them to
You
give
get it, I will keep it.
My lord, I will try to produce the SOP, which says frontier will be commanded by the IG, sector and training
If
superintendent.
you produce it, we are keeping it on any day. When do you want it? We will keep it and we will keep it. But this is very important. Frankly, Mr. Mishra, we would also examine 132 instead of saying that annulment not challenged. That is the area where we feel that the appeal
so
needs
thankful
to
for
be
it.
addressed. The other area we agree with the honorable single judge.
I have tried my level best to convince my lordship.
We are not here tried or whether
Whatever the outcome is, my lord,
no, we are trying to
my lordship, I understand.
see whether the
Act has been
findings are
followed or not.
correct or
My lordship, my lordship,
findings are correct or not.
my lordship.
Because in his lordship's order, I think relevant part starts from paragraph 40.
My lordship. It's a lengthy order, but the
I know it
relevant
doesn't matter.
is only
The
in two
NDS
paragraphs.
is not really very relevant.
My lordship.
So you've gone through the order. Page 35, paragraph 30. You see paragraph 30,
30.
29, 30, paragraph 29 onwards.
My lordship.
Paragraph 29, we agree. Now comes 30.
30 minutes.
Read 30.
At this juncture, it is apposite to note that the petitioner has not challenged the order of annulment of the proceeding. As rightly argued by the learned counsel for the respondent, if any person did not challenge and or not aggrieved by the initial order, then he cannot be permitted to challenge the subsequent proceeding. Now, my lord,
This is where Mr. Mojumdar, we are joining.
my lord, in reply
If
to
the
that,
annulment is the condition precedent for the jurisdiction to initiate the
Yes.
second proceeding, then a punishment in the subsequent proceeding would naturally inherit a challenge to the annulment. Separate challenge in our understanding is it is a jurisdictional fact. Then comes paragraph 31. Please read 31.
according to the petitioner, section 132 of the SSB Act would not have been resorted to in case of finding and sentence by SFC, and even otherwise, it is the central government, director general, or any prescribed officer who could have only annulled the proceeding under section 132. In the case of the petitioner, the annulment was done by an officer not authorized to do so as per Rule 185. Therefore, the annulment was bad in law. The aforesaid contention cannot be appreciated and or countenanced for the reason that the petitioner has failed to challenge the order of the annulment of the proceeding. Having failed to challenge the order of annulment, the petitioner cannot say that the annulment was bad in law. Now, my lord, just 2 pages, if I can refer to. One is I challenge the annulment.
Where
And the second, yes, my lord. Page 155, my lord, is my copy of appeal.
The other issue is not a big issue. If 132 power is in DIG, he had every authority to say that no, go for 44C.
At
Yes,
page 1,
was Mr. Mishra.
at
This
page
is where I
155,
want.
my lords, is my copy of appeal. Page
So
155, 155. This, my lords, is my copy of appeal, the appeal that I preferred. The appeal that I preferred before the IG, the copy thereof, my lord, is at page 155 of the paper book.
So first you say annulment has been challenged.
Annulment has been challenged.
To us.
Page 155, my lords. Point 4 and point 7. And then, my lord, this point.
Yes.
My lords, point 4 and point 7.
This is in your appeal.
This is my appeal that I prefer to the IG, the statutory appeal.
Where have you said?
Paragraph 4 says that sir, accordingly, I suffered the punishment of 40-day imprisonment with effect from such and such to such and such. In paragraph 7, the petitioner says that sir, a second trial out of the same offence is barred under such and such. The commandant has no power to amend his own order once it is implemented and communicated to the other party. The second trial against me is therefore illegal. So the order of the commandant in such and such cancelling the punishment is also illegal.
Is not the commandment's order. The DIG's order.
At that point of time, the DIG order was not known to me. It was internal communication between the DIG, JAG, and the commandant.
Correct. So we want to say, when did you come to know of the DIG's order?
When the second proceedings was given to me, my lords.
So this is after the second proceeding was given to you. This is after the second proceeding was given to you. It means 155 is an appeal against the second proceeding. So you were aware of the DIG's order and you have not challenged it in page 150.
9 minutes, para 9 for a moment, page 156. I say that it happened because of the advice given by the JAG.
That's a wrong argument. Because above the JAG, the DIG has said do it. So that was only a clarification from JAG. How do I start, in what manner, get a legal opinion, that is all. It's got nothing to do with it. You have not really challenged the order. But nonetheless, if this order actually is the foundation of the second security force court, we can go into this question and see whether the DIG would have directed second security force.
Because
Well, had it not been directed by DIG,
yes, things
the
would have been.
commandant would not have initiated the second.
Before the writ court, Milords, my argument at page 189, Milords, was that this is not a pecuniary or a territorial jurisdiction which can be taken at the first instance. This is a
Well,
subject matter
there is-
jurisdiction
there
that can
is-
be taken even at the second appeal. Page 189, Milords. There is no acquiescence or waiver if I submit to an
That is the thing. That finding we have to see whether it's correct or not. See, he says the annulment is in accordance with. As the petitioner did not challenge the order of transfer, there cannot be an estoppel on jurisdiction. If an order is perceived without jurisdiction, it's void. And if the annulment is void, accordance with law, ये देखना है. हाँ, if the DIG had a color of this, then the challenge and all is question. But DIG saying that I annul the proceeding, I direct you to initiate a new proceeding. कोई तो दिखाना, let them show it. Let them show it. Mr. Mojumdar, you have followed our contention.
I have to test out that DIG derives
You
power of
show us that.
And he's.
Mr.
that is-
Mishra, my brother has rightly indicated, come to page, paragraph 35 of the judgment.
My lordship. As stated supra, the procedures have been followed and the petitioner was afforded opportunity of his defense. The annulment is in accordance with law.
Now, this is a finding again,
My lordship.
without discussion,
My lordship.
that the annulment is accordance with
My
law, because his lordship in paragraph 31 says, in the case the petitioner, annulment was done by an officer not authorized to do so under 180.
My lordship.
Mr. Mojumdar, see paragraph 31, where his lordship holds last line, internal page 33, last line.
Lordship, in case of the petitioner, the annulment was done by an
Was
person not authorized to do so as per rule 185.
Okay, let us now stop here. Then how his lordship holds in paragraph 35, the annulment is in accordance with law. Thereafter, his lordship proceeds. As the petitioner did not challenge the estoppel, he cannot challenge in subsequent proceeding. We would also call upon you to answer, is there any estoppel against jurisdiction?
No, my lord.
If it
But-
does not, if he becomes an officer, as per rule 185, empowered to invoke 132, then whether challenge or not, that is the source for remand and reconsideration of the initiation. And that goes to the root of the entire security
My
force.
lord, I will bring out the document. which-
Please bring it out.
Because it is
Mr.
very,
Mishra,
very
this
much.
issue is what appeals to
My
us.
lordship. And I will arrange all the section and rules for my lordship.
Please do.
We'll do that.
Both of us, we find it, you run so fast and
No, no, no.
we are not so smart. So we
That's
take
okay.
time
That's
and
embarrassing,
we require a list before.
We will do that.
All right.
Duty bound.
My lord, when is it?
Whenever you come 1 hour later, we take up 1 hour later. It's for you to place on record. That the power is there.
Let it be.
Heard Mr. Mishra and Mr. Mojumdar, Deputy Solicitor General of India. Mr. Mojumdar seeks time to place documents, you want to place notification.
Compliance of rule 185.
Place notification on record to show the DIG concerned was empowered to exercise jurisdiction under section 132 of SSB Act read with rule 185 of the rules. All right.
Deeply obliged.
And another thing, please bring some authority on a jurisdictional fact. There cannot be a stop. It's not a case of dictation. It's not a case of dictation.
No.
It's a case of lack of jurisdiction of 130.
Yes.
Judge advocate's power is not really relevant.
I wanted to impress upon my lordship that it is acting under dictation, but it didn't cut ice with my lordship.
Oh, sir, first thing, it will be dictation when DIG you demonstrate has no jurisdiction. Then it becomes dictation.
No, Lords. What the Supreme Court says is that even if the power was there, if he says the particular authority to act in a particular way,
he has not
then
said anything like that. He has just said that these facts disclose a graver offense under 44C, and therefore the summary force court was unjust and illegal. Initiate a fresh. That power 132 gives to the officer concerned, central government and the DG, or a prescribed officer. Now, question is whether he is a prescribed officer. If he is not a prescribed officer, then his direction was without authority. And then comes, if it is without authority, it was an unauthorized person who initiated the, and on the dictate of an unauthorized person, the security force court was again reconvened on a grave charge. Huh? Yeah. You can arrive at that. Otherwise,
my lord says keeping it on Wednesday.
Any day, both are conveniently placed, sir.
Wednesday, my lord.
Wednesday. Mr. Majumdar, you will be given. Thank you. Yes, next matter. Forty-one.
Mr. Jana is appearing on.
Yes, Mr. Jana. Yes, Mr. Jana.
The impugn order, page 90.
90. Where is Mr. Jana? Where is the district magistrate's order?
Page number 78.
78.
Stay please.
The relevant paragraphs are paragraph number 3, 4, 5, 7, page number 78 and 79.
Yes.
The page 78, 78 last paragraph. But just my accordingly, the BL and LRO Tufanganj 1 submits a report on the field inquiry. No notice was served. I have stated, my lord, no notice was served upon the petitioners. Then, my lord, it has been reported that a plot of land under LR numbers 5411 and 5422, LR Khotiar number 128, land measuring area 20 decimal and 48 decimal, respectively, under Mauja, Andaram, Fulbari, jail number 71, are presently recorded in the name of Anil Das. Such and such. As under the course of river Raidak, along with other plots due to
The
change
thing
of the
is that Mr. Jana, whether the land was subsumed by the river or was used to build the dam. Now
just
you
my
said
the band of Rider River was constructed by the NDDD on plot number 5404, 5405, 5406. You will also kindly see page 46. Even my lord, the 5411, 5422, according to them, was not my lord the acquired, but you will also kindly see page 46. 46 of the stay application. This is my porcha in the name of our predecessor Anil Das, 5405, 5406. My lord, according to them, admittedly 5406, 5405 has been acquired, and my lord, the construct river band, my lord, was constructed on that plot.
Where?
Even, my lord, the excluding 5411, 5422. My lord, the all plots have been diluted, and page 52, you'll also, I have annexed a sketch map. All plots have been diluted. My lord, the 5405, 5406, 5411, all plots. You'll also kindly see. How the, my lord, without inquiry, my lord, the district magistrate has come to a conclusion. You'll also entire, my lord, the right hand side, you'll also will find 5407, you'll also got it. Page 52. 5407, 5405, 5411, 54. All plots, my lord, by dilution, my lord, all plots have been lost because of the construction of band. No, but these the villagers, poor villagers, their lands are not without inquiry, without my lord notice upon the petitioners, my lord, the district magistrate on the basis of the report of the BLRO have come to a conclusion that no, your plot has not been acquired. 5411, 5422. But we are the owner of 540506. Admittedly, that has been acquired.
The district magistrate is saying that land was not used to construct the plot. It was inundated by the course of the river. What Mr. Jana says is when the dam was constructed, there was an overflow by which the inundation.
Yes.
How can you, on that, how can you have an acquisition of land? It's not a question of acquisition of land.
And Miller, we are the owner of 5405. Well, that has also been admittedly acquired. They said.
They have not acquired that land.
Yes, page 79. They have stayed.
Where they are?
79.
Yes.
At the top, the band of Raidag River. You also got it, my lord, after 3 lines. The band of Raidag River was constructed by NBDT on the plot number 5404.
Right.
5405. 5405, we are the owner. 5406 is the such and such under Khotiar number. It has also been reported that no portion of plot of land under 5411, 5422. Maybe 5411, 5422 according to them has not been acquired. But 5405 has been acquired.
But your case is for 5401, 5411 and 5422.
Oh, 5405 also.
Where? Where is the repetition? For 5405 and 01. Where is your prayer in the repetition?
Page 46, my lord, this is the porcha. I have
correct. This porcha, Khotiar number, so and so, real number.
Yes, prayer A. You will also kindly see prayer A. Page 42, prayer A of the writ petition.
05.
Yes. And 5411, 5422 has been lost, my lord, by dilution. Entire plot.
For that, you will not get a compensation. Under the Land Acquisition Act, do you get compensation for dilution? Land Reform Act. For that section, the earlier amended.
That was section 11.
11 has been repealed and 12 now any 12 is an alternate is the alter ego of what has happened to Mr. Jana's client. Here it is a subsuming of land by the change of course of the river. For that there is no compensation envisaged under the earlier 11 that if something is subsumed again it resurfaces within 20 years a right accrues. That goes. What is said that if there is accretion of land, addition of land to an existing right, that also the right, the section to us, section 12 does not apply in this case. Does not apply in this case. Section 12 applies when it is that side of the bank which is accretion, is growing because of the change of the course of it. When the river changes course, a portion of the land becomes arable and another portion gets submerged. Mr. Jana's 5411, 5412 got submerged. All right. But what about 5405? That is a dark, as Mr. Jana indicates.
We have to see.
Please see, 5405 is acquired. His prayer is also for 5405. Then 5405. What was Justice Sinha's order? Can we see Justice Sinha's order? Mr. Jana, The problem arose elsewhere. In the direction. Where is Justice Sinha's order?
Page 74.
Now you come to your page, Mr. Jana, can you come to page 66?
Yes, 66.
Come to 67, third line from the top. Your representation was for compensation for 5411 and 5412. All right. And that is why her ladyship gave a direction for hearing on 5411 and 5412. To LR plot and not LR plot number 5405. Mr. Jana, we cannot help you here.
One more indulgence. The petitioners were present in person during the time of inquiry. There also, they did not raise any objection as to plot numbers. They could not produce any relevant papers at that point of time.
No notice was served upon the petitioners.
No.
Petitioner was not present.
Present.
That I have stated, my lord, entirely wrong.
Was the joint survey handed over to the petitioner?
In this repetition summary, I have categorically
Proceeding was done in presence of the petitioner as well as the government authorities.
But Mr. Jana, your representation annexed to writ petition 54 writ petition is only for 5411 and 5412. Page 67.
That is the, I have seen.
Please, can you take instruction on that?
Yes, that is the melody. I have to take instruction.
Please take instruction on that.
Parent of the records, my lord, the 5405. His porcha I have annexed page 46. My lord, he is the owner of the 5405.
Where is 54? Page 46.
Page 46, 5405. My the Anil Das, my lord, their predecessor.
Mr. A. वो नहीं है, only 5411 and 5412 किया है.
Not only representation, even the legal note is signed by Mr. Gandhi.
तो नहीं देखा है. 71 है ना, 67 के बाद. हाँ, फर्स्ट जो रिप्रेजेंटेशन किया वहाँ पे नहीं है. Even in your representation that you drafted at page 71. You have forgotten about 54105. But Mr. Jana, Acha, which is said that kindly come page 74, Justice Sinha's order. It says annexed at page 20 to 23 of the writ petition. What was annexed at 20 to 23 of the writ petition?
Twenty-two to 23, that is the land descriptions, my lord, which I am showing, my lord, the page 46, probably, my lord.
22 to 23. ও
Page
কেটেছে
42,
এখানে
that's the land description.
22, 23 হ্যাঁ where is 22 to 23 is the affidavit in the writ petition.
The present writ petitions, my lord, I have annexed. Earlier writ petition that was disposed of.
22 to 23 না বললেন writ petition का prayers में तो
And
prayers
my lordship,
505 है.
your lordship, my lord, the
One second, Mr. Jana. One
page
second.
52, my lord, kindly consider page 52.
Yeah, buddy.
Just, my lord, page 52. My lord, the act of-
Mr. Hey, Hero. Hey. Now you see, his lord, her ladyship is saying, consider the claim of the petitioner with regard to learned advocate is directed to forward a copy of the legal and a copy of the record of rights annexed at 20 to 23 of the writ petition at the time. So the record of rights include the record of rights in relation to LR 5005, 5405.
They have paid for only 2 plots, that is it.
Maybe, but then the writ petition is also and
They
the,
can apply, may I?
we remand this matter for reconsideration in respect of LR number 50.
They can also file separate application.
No, why unnecessary separate
Lordship.
application? Let the district magistrate consider his prayer
So for
in
505,
respect of compensation for LR 5405. All right, Mr. Jana.
As your lordship, my lord, the
Other
But-
two,
but the 5411, 5422, my lord, that has been diluted. Entire plot has been, my lord,
Well,
lost.
sir, for that you don't get compensation under the Land Reform Compensation Act, 2013 Act. From where do you get that law? Sir. Appellant has assailed the judgment order dated 1/3/2023, whereby the Honorable Single Judge dismissed his prayer to set aside the district magistrate's direction, the district magistrate's direction no. Where is district magistrate's decision?
That is at
Page number 78.
78.
78. 77, communication 78.
Order is at 70.
District magistrate's decision dated 1/3/2023 passed pursuant to
No, decision 23rd May 2023.
May 2023 passed pursuant to order dated 1/3/2023 in WPA 189 of 2023. Factual matrix giving rise to the appeal is as follows. Petitioner claims to be a riot. Appellant claims to be a riot in respect of LR plot numbers 5405, 5411 and 5412, JL number 71, Mouja, Mouja Andaran Fulbari, JL number 71, PS Tufanganj, District Kuch Bihar.
Petitioners are the legal heirs of the riot.
Anil Das.
Riot was Anil Das.
Oh, Anil Das, he is the legal heirs.
Yes.
Legal heirs of the riot, so and so, full stop. Petitioner contends that the said plots, that the plots in question were illegally acquired and utilized for construction of irrigation bath and village road by North Bengal Development Authority, NBDA, North Bengal Development Authority, NBD, NBDD.
North Bengal Development Authority, NBDA.
DA to, not DD, NBDD for short, full stop.
North Bengal Development Department.
North Bengal Development Department, NDDD for short. Accordingly, petitioner approached this court in WPA. Approached this court in WPA 1, Justice Sinha's order
74.
74. In WPA 189 of 2023, inter alia praying for grant of compensation for utilization of 16 sataks of land in LR Dag numbers 5405, 5411, 5412 of the aforesaid LR plots under the right to fair compensation and transparency in land acquisition, Rehabilitation Resettlement Act 2013, referred to as Act of 2013. Honorable single judge by order dated 1/3/2023 directed the district magistrate and collector to verify the grievance of the petitioners and come to a finding whether the private lands of the petitioner was utilized for construction of irrigation bath, after giving an opportunity of hearing to the petitioner as well as the representative of NDDB. Irrigation bath by NDDB without payment of compensation, after giving an opportunity of hearing. Pursuant thereto, the district magistrate, by the impugned decision, inter alia held that the irrigation bath had been constructed on the following plots. Had not been constructed on LR numbers, LR plot number 5411 and 5412, but had been constructed on other plots, including plot number 5405 in 5405, Khotiar number 128. होल्ड करेंगे So his is in LR Khotiar number.
Concerned two plots, 5411 and 5412 are in LR Khotiar number 128. But this for these 5405 falls in under LR Khotiar number 120. Page number 79.
At the page 52, everything has been recorded. 52. At the bottom.
Your LR Khotia number is 128.
Ela Khotia number 128.
But the acquisition is of 5405 in NR Khotia number 121. কি বললাম যেন?
পরে খতিয়া নয় না এটা আগের খতিয়া পরে আরেস খতিয়া
5411 and 5412 of LR Khotia number. Here he has given GL number.
First line 120.
LR Khotia 54 in LR Khotia number 128. But on other plots. Full stop. Mr. Jana contents the district magistrate. Mr. Jana contents his client was not given an opportunity to present his case before the district magistrate. No notice of the field inquiry is relied upon. No notice in respect of the field inquiry undertaken by BLLRO Tufanganj 1, which was relied upon, had been given. He had also, he has the report is also silent with regard to LR pot number 5405. Khotia number 128. Khotia number 128 is concerned. Full stop. Per contra, Mr. Hirok Bormon and Mr. Sumit Kumar contend none of the aforesaid plots were utilized for construction of the irrigation bath. LR plot number 5411 and 5412. LR Khotia number in LR Khotia number 128 was submerged due to change of course of the river and not for construction purposes. The plots utilized for construction of the bath also does not include LR plot number 5405 in LR Khotia number 128, but other plots including plot number 5405 in LR Khotia number 121. We have considered the submissions at the bar. We have perused the decision of the impugned decision of the district magistrate in light of the submissions at the bar. First issue raised by Mr. Jana is that his client was not given notice in respect of the field inquiry undertaken by the BL and LRO concerned. Accordingly, he was unable to effectively present his case before the magistrate. We find little substance in the submission. Field inquiry report submitted before the district magistrate clearly divulges, clearly indicates plot numbers so and so, page 79. Plot number so and so. It clearly indicates that the irrigation bath by NBDD was built on plot numbers so and so. The plot numbers referred to the plot numbers. Now, petition, nothing is during hearing, petitioner did not raise any objection to the said report, nor did he place any document to controvert the finding, the aforesaid finding. His claim is related to plot numbers, LR plot numbers 5405, 5411 and 5412 in LR Khotian number 128. None of these plots had been utilized for building the irrigation dam. In such view of the matter, we are of the opinion, the manner in which we are of the opinion, ample opportunity was given to the appellant, appellant to controvert the field inquiry report and make out a case that the aforesaid plots were utilized for dam construction. The second issue raised by Mr. Jana also does not deserve, is also unmerited. He argues LR plot number 5411 and 5412 was submerged due to change of course of river Roydhak when the irrigation dam was constructed. His appellants are entitled to be compensated on this score. We on this score, provisions the provisions of the Act of 2013 inter alia provide for compensation of land acquired for a public for land acquired for public purpose. Inundation of lands of the appellant's land by change of river course is not within the scope of the said law. Full stop. In such view of the matter, within the scope of the said law, in such view of the matter, the prayer for compensation of inundation of LR plot numbers 5411 and 5412 in Khotian number in LR Khotian number 128 would not justify grant of compensation under Act of 2013 to the petitioner, to the appellant. In light of the discussion, as aforesaid discussion, we find no merit in the appeal. The appeal is accordingly dismissed.
Great.
Yes, next matter. Anuyuta Vishwas.
Unanimous appeal.
Yes.
This appeal is delayed by 71 days, my lord. The appellant is 71 years old man, my lord.
71-day delay for a 71-year-old.
Yes,
man. We will condone the delay. Who are there for the respondents first?
I represent the state.
Mr. Sumit
Private
for the state.
Lodge.
And
We
private,
We are
Private
private
respondent.
respondent.
7.
you are private respondent. You are for accused,
No, my lord.
for the victim.
No.
Is for the accused, my lord.
Yes.
My lord, for the no, I am not for the accused actually, my lord. Accused, I am for the
Who is the
parents.
appellant? Is he an
Appellant is the
accused?
parents-in-law, my lord.
So they are not accused.
They are accused,
Then-
they are on bail, my lord.
So what do you, what is your grievance?
Grievance is that, my lord, we are old. Now, the case started, the moot point was that.
Sir, what is the, please come to the impugned order.
My lord,
He's currently staying outside Silver and goes.
the lookout notice against my son, my lord.
So,
Lookout
who
notice.
are you?
My lord, he is my son and he is.
All right, the
we
appeal
are-
is not maintainable. Appeal is not maintainable. Appellants are the parents of one Namolo. Not accused of one Rudraksha Ghosh, who is the accused husband. He had absconded.
No, my lord, he was working there in Dubai for prior to initiation.
He had absconded and pursuant to and the honorable single judge, on the prayer of the de facto complainant victim, directed police to issue lookout notice. This is the subject matter of challenge at the behest of appellants who are his parents. We are of the considered view, appellants are not aggrieved and cannot have locus to assail the order. Good stuff. Appeal dismissed. Delay condoned. Dismiss the order. It shall be open to the aggrieved person to initiate, to take necessary steps in accordance with law if so advised.
Lordship. Lordship.
बाप किया है तो पीता है देखी तो लड़का किया है तो बाबा. Yes, next matter.
Lord, I appear for the evidence.
43 Hero.
As for the applicant.
Interim order too.
My lord.
There is nothing in it.
My lord, may I take 2 minutes, my lord? My lord, the impugned order has passed the scope of the act, my lord. And that is why we have been aggrieved, my lord.
Correct. So let that issue be
My
decided.
lord, my lord, may I be permitted to place my one judgment, my lord, and the act, which would.
ये देश में तो इतना है कि इनका प्रोविजन बन गया खत्म कर दिया है country 3 times. I was thinking of this summary force. फोर्स कोर्ट में एक बार होगा, उसका अपील एक बार होगा, रिट पिटीशन एक बार होगा, उसका अपील एक बार होगा. 5 rounds. The man who died. That is good. Please be the case. Yes,
Yes. My
tell
lord,
us.
the petitioner before the writ petition had challenged a valuation based on an impounded document that was taken by the collector, my lord. My lord, the only impugned question before the learned, before the single bench was the date of assessment, my lord.
Right.
The collector had assessed on the date it was presented before the collector after impounding. My lord, the law under section 2 subsection 6 defines chargeability. Chargeable should be from the date when the document was first executed. Now, my lord, the value.
So you say that even if it is presented later on,
Yes,
the date of
execution.
execution is the date
Date
at which
for-
the rate will be
Yes, my
determined.
lord. My lord, this view has been taken by the Honorable Supreme Court and affirmed in 2023, my
Already
lord.
there is a direction for filing affidavit.
My lord,
This
there is no
one-
disputed question of facts
And
for which an affidavit was
there
called
is a
for, my
separate
lord.
appellate provision. They can
There is
prefer
no
a-
appellate
Yes,
provision,
yes.
my lord.
They have also filed the memo
No, my
before the
lord.
divisional commissioner.
The divisional commissioner,
47B.
that jurisdiction is beyond
No, no.
47B, my lord.
So in this situation, what can we do when there is a direction for affidavits?
My lord, that direction, my lord, has,
they have
my lord,
admitted to pay
kindly,
the
my lord,
bonds.
how the appellant will be aggrieved, my lord, because my lord, the writ petition has been directed to submit on the current date of valuation, that is on the date the order was passed. Now, my lord, that will again, the collector has to assess on the current date.
Can we do like this? Request that the issue be considered in the light of the judgment delivered.
Yes,
in
my lord.
court.
It can be directed to the collector if it could be.
What
My lord, it could
We
be.
will allow the writ petition and direct the collector.
Petition is
Is that
pending.
the scope of this appeal? What relief, interim relief you can ask?
My lord,
Your judge said that though the determination was in 30th July, writ petition is instituted after 6 years.
my lord, the petitioner has
Can't you have patience for a second?
applied.
So, examine the order. You are challenging an order. Examine it with regard to its legal infirmity. And the legal infirmity you say is the determination or the writ petition are not relevant. What he's saying, what his lordship is holding is there is inordinate delay in institution of the writ petition. There is the determination, the decision of the collector is in 2018 and it has become final and binding. No appeal was preferred within the time frame prescribed.
That is not the fact. The petitioner had challenged that valuation, but before a wrong forum. My lord.
Correct. When?
My lord, immediately after the determination was made in 2018 itself.
Then it was wrong forum when you came to know it was a wrong forum.
My lord, it was disposed of by the Honorable High Court in the year 2023, my lord.
So High Court means again you moved a writ petition.
No, my lord, a revisional application was moved, my lord, under 227. That the court found that the trial court was
So
not.
this issue requires to be decided by the single judge.
Yes, my lord, but
Right.
subsequently, my lord, there is a direction to the appellants to deposit an amount based on current valuation.
Where is that direction?
My lord, that is at, however, pendency of this matter shall not preclude, page number 128.
No direction, they were given liberty.
Liberty.
My
So
lord,
yeah,
but
this
for that, my
liberty you
lord,
need not act on. You need not act on that liberty. Right?
My lord, if that would be so, my lord, my suit will be infructuous before the trial court, my lord. If there is no stay in the impugned valuation.
We cannot help you.
My lord, if this deposit could not be have been directed, my lord, because it says it has to be made on current valuation, my lord. That is the only portion we are aggrieved. We are ready to deposit If it is as per the act, my lord, if it is a lawful amount that has been given.
Let us see what is the, shall not preclude them to get the instrument registered based on the current determination. So what was the determination in 2018?
My lord, it was on the date 2018. Now the court has
Sir,
directed
you will deposit as per 2018 direction.
that we are ready.
Subject to the result of the
Writ
writ petition. Correct?
That can be done.
That can be done.
Yes.
Instead of 2025 determination, there is a determination in 2018. That is challenged. According to him, the challenge was before a wrong forum, and then he has moved the writ petition.
Our submission, it is not, we have got the instruction, it is the right forum there, but they have not raised that appeal.
No.
47B, the commissioner is the appellate authority. We have taken instruction, specific instruction that
Commissioner
he is till now hearing that he has jurisdiction and hearing the matters of
Then
challenging the valuation of the collector.
where is that order?
47B.
My 47B is not applicable in our facts.
No, no, it is applicable.
It is in
because the
case of
order is
violation of
followed by-
47A. Our case is under section 35.
Where is the order of OC 1 of 13?
My lord,
Where
page
is
number 95, my lord.
page? $95.
Anyway, CO revision.
Divisional commission.
My lord, divisional commissioner.
Can you, sir, please place the order? Lecture.
My lord, the order of. My lord, page 88 is the evaluation report, my lord.
What we do, Mr. Hero, all issues are kept open. We modify the liberty that he would be at liberty to deposit the determination as per 2018 assessment, subject to the result of the final result in the report. All right. Hard learned counts for the parties. Must be a finally. Because evaluation was done in 2018 when it was in the because it's 2018. Nothing. So let them deposit that amount. What was the deposit amount that he presented? Necessary fees based on no current determination of valuation on land. Determination of market value in question. It appears those such determination was made in 30th July, revision so and so, questioning such a market value. So he says that on the current determination of valuation of that. So we clarify that the current determination is 2018. Yes. लिखो लिखो no, hold on. Appellant had entered into an agreement for sale of a property in 2010. On 18/8/2010. In 2012, he instituted a suit being OC 1 of 2012, seeking specific performance of the agreement. The agreement being unregistered and insufficiently stamped, he made an application for impounding of the said agreement under Section 33 of the Indian Stamp Act. By order dated 25/2/2016, the civil court impounded the agreement, the document, and sent the same to the collector under section collector for evaluation of stamp duty, for determination of evaluation of stamp duty on the said agreement. Section 40 is evaluation. Indian stamp.
Adjudication.
Huh? Under
But
section.
it's the 40 is collector's power to stamp impound. The 38 is
Now, to determine the stamp duty and file a report before the court. Pursuant thereto, evaluation report dated 17/9/2018, 37/2018, was submitted, wherein the chargeable duty was assessed on the market value prevailing on the as on 37/2018. This was assailed before appellant assailed the evaluation report, unsuccessfully assailed the evaluation report before the civil court, and before the civil court, and thereafter challenged the order of rejection dated 4/11/2019 in a civil revision being CO 14 of 2020. The civil revision was dismissed on 2/12/2021 on the ground that appellant had on the ground of existence of alternate appellate remedy. Appellant, however, did not avail of the alternate appellate remedy, but assailed the evaluation report afresh in the writ petition. In the writ petition, in the present writ proceeding. Honorable single judge, inter alia keeping the issue of maintainability open, directed submission of affidavits. Honorable, Honorable Judge also gave liberty to the appellant to gave liberty to the appellant to get the agreement for sale registered on payment of requisite stamp duty and necessary fees based on current determination of land in question by 14th February 2025. Learned counsel contends that the chargeability of stamp duty is on the is based on the valuation assessed as on execution of the agreement, that is 2010, and not at the current determination. This issue as well as the issue of maintainability required to be decided by the first court upon exchange of affidavits. However, on exchange of affidavits. However, exchange of affidavits. However, we clarify that the appellant would be entitled to submit to get the, however, in the meantime, it shall be open, however, we clarify, in the meantime, it shall be open to the appellant to get the instrument registered upon payment of stamp duty and necessary fees as per the impugned assessment, as per the impugned evaluation report dated 30/7/2018, subject to the result of the writ petition. All right, the payment, but we need not specify date also. It is up to him whenever he pays it. With this direction, the appeal is disposed of. I've seen it. Yes, your book. This book. Yes, next matter.
The application to restore and mandamus appeal.
Has service
Served.
been? You are for?
I am for the appellant, my lord.
Appellant. All right. Having considered the, you have served the copy?
Yes, my lord.
I am responded about 7 your lordships.
All right, then you are the effective writ petitioner.
Yes, lordships.
All right. You
No,
have
no, my
not-
lord. I am the writ petitioner of the court below.
All right.
Earlier occasion, I have filed a REIT application, your lordship.
All right, then we restored the appeal.
Lordships.
We are having considered the above
Considered,
the application. The prayer for the restoration application is allowed. Appeal is restored to its filer number.
Get from
Original filer number. Next.
you can leave, my lord.
Yes, Mr. Rai.
Sorry, but I could not reach. It was delayed because
our customer became sick in the move to take off, it takes 2 hours more. Is it?
I was told it could not take off because of excess weight.
Excess weight? No. But it's the first appeal, my lord.
But can we, let's, subject to Mr. Roy's consent, my lord, I think my lord, it can be placed before the next circuit.
Why?
He wants to argue for some time.
Yes, my
No,
lord,
no,
you
he-
also have to argue for some time.
I know, but not today. At 4 PM, you cannot do.
Can please today, but he has filed also additional evidence, but that is not
Can
required.
also pending, which
He-
is, my lord, essentially
my
an
lord-
application under 41 rule 27.
I say
which
it is
he
not,
has
it is
filed
not
any opposition.
relevant because
So
this is my,
that
sorry,
has to be.
Where
heard.
is can?
The can is in the list, my lord.
yes, this is also,
Let us do some effective order. Heard Mr. Roy.
well, can you take it tomorrow? Can you hear this matter?
Let him file
Can-
a short
can-
opposition to my can.
No, I'm not,
He
it's not
will
required.
dispose
It's
of
not
the
required.
can by saying that the can shall be disposed of along with the appeal.
No, my lord.
Excellent.
No, my lord,
No,
no,
no difficult.
no, my lord.
No
But
difficult.
kind of this, sorry, my lord. I
Then-
want this one.
Then
So-
argue on the can.
Subject to loss, can you see? He's the dependent.
Huh.
I just a minute. This is my shoot. The shoot for my declaration of title and recovery position on the basis of the title under Article 65 of the Limitation Act. And he was a dependent. His case is half. One says, I'm in a position, somebody says, I'm in an adverse position, and she also made a counterclaim for title. In the shoot, that was dismissed on the ground of on the limitation. Gandhi just says, you have been here, you have been dispossessed 12 years, before 12 years. He applied Article 64. Here, my lord, the title, only based on title, it should be his position should be adverse. Article 64 is applicable. I paper this appeal.
All I make it not today.
Here's what is very, and he filed now, he has not papered any cross appeal, not appeal against the counterclaim. He has brought a document, order 41 rule 27, which is mentionable. It is not his appeal. No, it is not, no. It is not his, hear this matter tomorrow.
May not be his appeal, but he is entitled to place on record additional documents.
No, the subject also can smell. When order 41, rule 27, any parties can do it. But it is subject to also consider. Here, the issue is whether shoot is barred by limitation or not.
Correct.
Here, he posted one document.
Mr. Roy, if we hold that the suit is not barred by limitation,
My shoot.
your suit, and it needs to be reheard.
Yes.
So order 41, until and unless he can place some document which aids the reasoning of the dismissal of the suit on the point of limitation, they will be irrelevant.
Yes, he was absolutely correct. He absolutely correct. But he's not, he said by title, he's trying to prove a title. This is not there. He's shoot. He's the counterclaim. Can you also can hear me?
The thing is that if the suit is not barred by limitation, whether the matter ought to be remanded for rehearing.
Yes.
There maybe he is taking out an application under order 41 that on other grounds also his prayers are not maintainable. Without hearing him further or you anymore, if we are with you that the issue of limitation has not been rightly applied, we will give him liberty to place these documents in the course of the trial of the case.
Absolutely, no difficulty.
But-
I mean, in course
but-
of hearing of the final appeal, if your lordships feel that this document
No.
might aid your lordships in coming to a conclusion.
No,
in
my,
that-
your, my,
your lordship can
The
advert to that.
question is, should we go into other issues in the appeal? Has the appeal been decided only on the issue?
on the limitation, my lord.
On the issue of limitation?
Because if you file a cross appeal, then he can do. You kindly appreciate
The
that.
reasoning for preferring.
If you file a cross, he has not filed a cross appeal. Because can you see my should was dismissed on the counter limit?
Cross appeal is not always necessary. We can always argue
No.
on.
No, you can appreciate, sorry.
All right, we'll see tomorrow. We want to argue what?
More kindly.
Tomorrow.
Yes. That's all.
Yes, next one. Done. Interim order. Next.
46, my lord, I appear for the appellant. This is a suit for partition. A preliminary decree has been passed. I am the defendant number 6 there, my lord. Now, the defendant number 1 before your lordship, the plaintiff, he expired, my lord. His legal heirs have been impleted. Service has been effected, my lord.
So it will be heard out on merits.
Yes, my lord.
So we keep it after the next level. It takes some time. Can't finish it.
There's your lordship.
The paper books be prepared.
Yes, my lord. Paper books may be prepared.
Give a direction for preparation of the.
Yes, my lord.
Appellant is directed to prepare
Paper book.
requisite number of paper books, and you have got a can for disposal.
Can is the stay application, my
There
lord.
is no question of stay. It's against preliminary decree.
Against the preliminary
So
decree,
let the suit continue,
my lord.
and the final degree shall be passed with the leave of the court.
As your lordship.
All right. Heard learned counsel of the parties. The appeal is against the preliminary decree. Trial judge shall proceed with the hearing of the suit. However, final decree may be passed after leave of taking leave of the court. After taking leave of this court, appellant shall prepare requisite number of paper books, etc., etc. Notice of appeal dispensed. Notice of appeal dispensed. Liberty to much.
My lord, item number 47, my lord.
Yes.
In this matter, my lord, I am appearing for the my lord appellant, my lord Das. This is first appeal, my lord, arising out of an application filed under section 18 of the Land Acquisition Act 1894, and has been filed under section 54 of the said Act. My lord, the case is also running under bar by limitation, and we have also filed an application under section 5 of the Limitation Act. As well as an application. My lord, we have also served the section 5 application upon the private respondent, I mean my lord degree holder respondent twice. My lord, the said parcel has been returned with the remark on address he left twice. Then third occasion also, when the matter came for hearing before the Honorable Circuit Bench, the learned division also directed me to further send the notice. In the meantime, my lord, I have also my lord directed our officer to get the proper information regarding the local of the regarding the residence of the said person's degree holder. Otherwise, my lord, the parcel is always we are serving, but it is returning with the remarks left. So, my lord,
there is a direction for substituted service.
Substitute service, my lord, your lordship kindly pass that kind of my lord. That
Sir, there is an order on 6/1/2025. We don't understand. Why don't you, for heaven's sake, check out the orders which are passed in an appeal? Please see the order of 6/1/2025. Appellant is directed to serve the respondent or take steps to effect substituted service in accordance with law and file affidavit of service. Affidavit of service be filed on the adjourned date, next available service.
Substitute service, get future.
No, we don't understand why this exercise is just looking to the earlier orders. Next.
Lordship, I appear for the appellant.
I'm for the respondent, lordship.
Lordship, this is a partition, this is an appeal against the preliminary decree part in the partition suit. Can one
All
of
the respondents are before us?
Lordship.
So let the paper book be prepared.
Lordship, there an application for limitation.
Condonation of delay.
Condonation is 4,778 days. Lordship.
You file your opposition.
Opposition
They have
already
already
filed.
filed the
Then
affidavit in
on
opposition.
what ground will be called?
Lordship, so they are appeared on the final decree
No.
and the execution
No.
proceedings has been
No.
started. That has been.
No, no,
that
no,
has
no,
been.
no, no, Lordship, kindly allow me to place.
Yes, you can place 4,000 days.
Like
Fine,
4,000.
And final decree has been passed, we are not going to
Lordship,
interfere.
Execution has been already been
Lordship.
started. Execution, he.
In the year
there's
2000, Lordship, in the year 2011, 23rd May 2011, the preliminary decree was passed. And soon.
Please prepare a
and-
list of dates and show us how the delay is explained. How you have explained the delay?
Lordship, 3 consecutive days in a family.
So what?
Lordship, the original defendant who used to defend the suit, he passed away.
Correct.
Immediately after passing of the preliminary decree, his son was diagnosed with cancer. Thereafter, his son-in-law was diagnosed with cancer. For the treatment of both son and son-in-law, this defendant was extremely engaged in that matter.
When was the decree passed?
23rd May 2011, Lord.
23rd May 2011.
And final decree passed on.
What?
25th to 23rd.
And he participated in the proceeding before the trial?
Finally, yes.
No, Lordship.
No, but
No,
no,
sir, kindly,
he
Lordship.
had been, he appeared through learned advocate.
No,
Learned advocate also been appeared in the final decree.
That is why we are saying, sir, he appeared means is he represented?
Yes, page number 23.
One second now.
Okay.
When the preliminary decree was passed?
23rd May 2011.
23rd May 2011. Final decree?
Passed on, final decree passed on. 2nd October 2022.
2nd October 22. And this appeal is filed?
In the year 2024.
In 2024. When the final decree was put into execution?
Execution, one second.
Sir, please, tomorrow, please prepare a list of dates and help us,
Lordship.
which should show that they had, in the proceedings before the trial judge, participated.
In final decree.
No, Lordship, during the drawing of final decree, these petitioners were not represented. When the original defendant died, there was a substitution petition filed by them. And during that time, for one day, they appeared, thereafter went absent.
So they appeared.
But when the final decree, actually, Lordship, they were not properly advised.
Though advised will not do. Advised will not
For
do.
2 days they appeared.
You
no
are
effective step
saying
was
that
taken.
they were so much involved in the medical misfortunes and the deaths, they could not find appeal. But they appeared before the trial judge.
Through an advocate.
Naturally, nobody appears in person until unless you go give deposition.
For 2 days only they appeared.
We
thereafter
don't.
They went absent.
First, we want 2 days, 3 days is irrelevant. You participated in the proceedings. That's why, sir, please give us those dates.
So execution proceedings. Lordship, I will come on tomorrow.
Really, it's such a struggle now. Things why things are so delayed. No ground. Where is your opposition?
Lordship, opposition filed on 28th November 2024.
Let us see what you have said. এটা কেটে একটু দেয়া ওনাকে দিলে তো সুবিধা হয়। In your opposition, you don't say that you made a substitution application.
Your lordship.
Please, sir, come to your opposition. Come to page 3, clause C.
See, lordship.
Please read out.
To the preliminary decree in the petition order partition suit number 924, the respondent herein preferred an application under order 26 rule 13 with procedure code paying for final decree. A suit was concluded in the preliminary form. In the said suit, final decree predecessor of the petitioners were remain present through learned advocate and the presence of the learned advocate of the parties of the suit on 4th July 2024. The final decree was passed. And the said knowledge of the passing final decree is within the knowledge of the petitioner, lordship. They have been substituted. Lordship.
Where have you stated?
No, lordship. That is,
Where have you stated that?
but
You have spoken of the predecessor in interest participating in the proceedings for drawing up of the final decree.
yes, lordship.
Post the demise, that you took out an application for substitution.
Lordship.
The substitution application was served. They entered appearance, and thereafter the final decree came to be passed. Is there anything in your opposition?
Lordship, when I was at evidence file, I have failed to trace out the original record. Thereafter, I got that original record, and I have collected all the papers. And then they have been appeared to the advocate. That is Vakalatam also been.
So please place on record those.
Lordship, can you give me an
Lordship, kindly
opportunity?
consider page number 24 of their
Opportunity.
of
I
the
have
final decree actually, Lordship. Final decree was drawn up against my predecessor in interest, not against me. Although they are saying that I have been substituted, but it was not practically substituted because decree has been final decree.
That's an error in the decree. That is an error in the decree that will not take away your knowledge of the proceeding and participation in the proceeding. Don't thrust papers under our nose until and unless it's properly pleaded and placed on record.
Lordship, can you give me an opportunity? Then I can take additional.
Learned counsel for the appellant learned counsel for the respondent number 7.
All this.
Respondents seek leave to file additional affidavit in opposition. Leave is granted. Additional affidavit in opposition be filed within 2 weeks. Reply, if any, 1 week thereafter. Matter will appear before the 4 weeks end. Yes.
Lordship, in item number 49, there was a direction to serve upon the respondent. Service is not complete.
Service is incomplete. Next available circuit, affidavit service be filed. Next.
Your Lordship, item number 50, for the appellant. We are yet to affirm the application for injunction and stay. Kindly grant us 7 days' time and keep this matter in the next circuit, Lordship.
On the period of the appellant, next available circuit.
Grateful, Lordship. Thank you.
Lordship, in item number 51, I am for the appellant. Against the impugned decree arising out of suit, matrimonial suit, impugned order dated 10/4/2019. Actually, in this matter, Lordship, what happened at the time of filing, there was some defects. On Justice Rai Chatterjee's bench, we have removed all the defects.
So the appeal is filed after 7 months. 9 months.
Yes, sir. Lordship.
Why?
Actually, Lordship, at the time of filing, I was not the recorded lawyer. Then subsequently, I appeared in this.
Have you served notice of the?
No direction was
To
given.
give notice of the condonation of delay application.
Oh yeah, I've already filed can application.
Huh?
Can application was filed.
Has been filed.
Yes.
It's can 1 of 2022.
Yes, yes.
A copy of the application for, oh no, staying operation. Okay. Where is your delay application? Can one of speak? Oh, delay. Your application, there's delay of blank days. You have filled up the prayer portion.
Your Lordship, I was not a recorded lawyer.
Sir,
That's
madam, we are not. Who is recorded lawyer? Who is unrecorded lawyer? You're moving the application. Please make necessary correction in the prayer portion. Liberty to correct the prayer portion of the application of can 1 of 2022. Can 1 can blank হয়ে আছে can blank can লেখা আছে 1 লেখা can 1 of 22 copy of the application be served upon the respondent. After the service be filed, matter will appear 4 weeks after 2 weeks. 2 weeks.
My lord, I'm for the applicant, my lord, kindly praying for a not today, my lord. My lord, praying for a not today.
Required to file affidavit in opposition.
For what?
They have made certain allegation against that.
No affidavit, second appeal, what?
Second, first.
First appeal.
It's a first appeal.
Can is there or?
What have you challenged?
The order of injunction, their allegation is that we have violated the order of injunction.
All right.
And made
To file an opposition. Thing in the interim order.
Till disposal of the can. The order passed.
Yes. From changing nature and character of the property, yes. No, he's come up against an ad interim order.
No, thereafter it was confirmed on.
On 7th of June 2022, it was.
You're for the plaintiff.
We are for the defendant.
Hmm?
Appellant is the plaintiff.
Appellant. Let's get them finally up. It's not in. There's your general power of attorney empowers you to make changes in the property.
So that is their allegation, Lordship.
We are saying, does the general power of attorney empower you to make changes in the property? Affidavit in opposition will be filed within 2 weeks. Reply 1 week. Matter will appear 4 weeks since.
Lordship, I request we stay.
Item number 53, I'm praying for next circuit.
Next circuit.
I'm great. Have it.
I'm praying for not today.
Not today. Not today.
I'm praying for next circuit, Lordship.
Next circuit.
Lordship, item 57 praying for next circuit, Lordship.
Same.
Take it.
Lordship, item number 58, Lordship, I'm praying for not today.
Not today.
Grateful, Lordship.
Not today.
61, next circuit.
Next circuit. Not today.
62.
Appeal is defective. Defects we remove. Next circuit.
63.
63, your Lordship, the first appeal against the income tax tribunal order within time, your Lordship.
We hear out the matter.
There are section 260A of the Income Tax Act, your lordship.
It's not a first step, you have to,
First step.
questions of law have to be framed.
Lordship.
260 is not a first step. It's
Lordship.
against the appellate tribunal's order.
Lordship.
So
We
what are
have
the
filed-
questions of law?
Lordship, we filed the appeal in the form of SAP, but subsequently, your lordship, the appeal, corrected by FMAT by the order.
All right, FMAT, but still then the question, under 260A, questions of law have to be framed
Sub-
as to what are the, all right. We keeping it tomorrow?
Lordship,
You formulate the questions of law.
lordship, substantial question we have already framed in my application.
Let us see.
Lordship.
Other matters tomorrow.